Yes.
Yeah, please, Lord. Item number 38, Lordship, may kindly be adjourned for 2 weeks, Lordship.
30?
38. With
30?
the consent of the other, he also, my learned friend also needs to obtain instruction.
38.
Lordship.
Contempt, huh? For the prayer of learned counsel for the release this matter after 2 weeks.
Let it be after the vacation.
After 3 weeks.
Lordship.
All right.
Make
all
it
right.
4 weeks. 4 weeks.
My lord, similar prayer in respect of item 42, my lord.
42, yes. Same order. M.A.H.M.R. Chaudhary.
Yes.
Ah,
All right.
May it please your lordship.
yes.
I'm paying for my lord listing of one IA, my lord. My lord, we have filed for my lord vacation of stay order, my lord.
Hmm.
This is regarding my lord the railway line newly constructed to Mizoram, my lord. Bhoirabi to Sairang, my lord. This is where Bhoirabi to Sairang, my lord.
Hmm.
Mizoram, my lord.
Hmm.
Which is my lord, will be open, my lord, in the next month, my lord.
Huh.
There is a stay order, my lord, regarding my lord one renovation of one station, my lord.
Hmm.
So, my lord, we have filed, my lord. This is very important, my lord, for my lord opening of the rail line, my lord.
Hmm.
And I am informed, my lord. So that may be taken up on Wednesday, my lord, next.
Ma'am, please, your lordship. Number 28, my lord. I appear for the IOCL, the respondent in this matter, my lord. We are praying for some time to file our affidavit in opposition. I have the consent of my son. My
Okay.
friend for the
On the
petition.
prayer of Mr. M. Sharma,
Yes, madam.
learned standing till IOC, further 3 weeks time is granted to file affidavit.
Petitioner,
MS
B. Doctor.
B. Datta
Lordship, interim order to be continued.
has resist no objection. List of interim order pass let's continue.
Grateful.
May I
Ms.
please, your lord?
B. Datta for petitioner, huh?
May I please, your lord? Look, I have filed an urgent petition yesterday, my lord.
Ah.
So let the matter come for listing Monday, my lord.
But
Regard-
it's very difficult. So many matters.
urgent matter regarding settlement of fishery, my lord.
So
Even after the expiry of 1.5 month, my lord, as yet no settlement has been made while I am the highly tender.
no, allotment is not. It's not been allotted.
Not been settled.
Settle. If
Yes.
you have already waited for another one year,
My lord,
let us
already
wait
1.5
for-
months already gone.
Huh?
1.5 months already gone, my lord.
So
Monday.
not Monday, Friday
May I please, your
or Wednesday. Wednesday.
May I please, your lordship?
Yes,
Lordship,
yes.
I'm praying for listing of for withdrawal, lordship. Monday, lordship.
Yes.
May it please, your lordship.
Hmm.
Lordship, I beg to mention item number 11 of the daily list, your lordship, with
Hmm.
the consent of the other side.
Ah.
Lordship, my senior Mr. K.M. Chaudhary is out of station, your lordship.
Okay.
Therefore, I kindly pray this matter may come up after a week.
On the prayer of Mr.
T. Kashyap, your lordship.
T. Kashyap, London Council. List this matter after a week.
Lordship, may I pray for a date?
After a week? It's a motion matter. You are
Motion.
praying by adjournment.
Not sure.
That will be lordship. Also, I beg to mention item number 3, lordship.
Hmm.
Item number 3, lordship, we need 1 week time to file additional affidavit, lordship.
Why?
As per direction of the last
On the prayer of Mr.
B. Borgum, lordship.
B. Borgohalan, Counsel for petition. List this matter be listed after 2 weeks.
After 1 week, lordship.
After a week, so as to enable him to file appropriate
Yes, sir.
affidavit. Huh?
Must be.
Not appropriate, additional affidavit, huh?
May I please, your lordship? Lordship, I beg to mention item number 45 and 46
Hmm.
of the daily list.
Huh.
We have filed the affidavit in reply, but still is in record, it is not shown.
So,
Kindly grant 1 week time,
on the prayer of 44 and 45,
45 and 46.
45 and 46, huh? You are Mr.
P. Sharma on behalf of R. Chakraborty.
So and so learned counsel appear on behalf of Mr. R. Chakraborty. Let this matter be listed after 2 weeks. Huh? 2 weeks?
May it please, your lordship.
Yes.
Lordship, paying for listing of an IA for impleadment of party, your lordship. Lordship allows on 3rd of next month, your lordship. Keep your lordship.
May I, lordship, petitioner also, item number 40, my lord. I'm not able to contact the petitioner, my lord, so kindly 1 week time may be granted.
On the
for
40, on the prayer of Miss
this one, my lord.
this one, well, learned counsel for the list this matter after 4 weeks.
Wait, please, your lordship.
Yes.
My lord, filed an additional affidavit.
Hmm.
Now, here also again, difficulty, just like the other day I presented a case.
Hmm.
My lord, direction was upon the department and district commissioner
Hmm.
for carrying out the order. Now, upon the district commissioner, the notice has been served by hand.
Hmm.
He has received it by hand.
Hmm.
So far the department was concerned, we dispatched the certified copy of the order to the joint secretary.
Hmm.
The
Who has to
envelope-
comply?
the department is to sanction the amount and the district commissioner is to disperse as per
Ah,
the order.
So until then, it is the
Yes.
sanction.
So again, I pray this may be closed.
Ah,
We may be allowed.
Mr.
D. Chakravarti.
B. Chakrabarti, learned counsel for the petition submits that he may be allowed to withdraw this contempt petition with a liberty to submit the order of this court before the appropriate authority. Mr. Prayer is allowed. Contempt petition stands withdrawn, stands closed on withdrawn with a liberty as prayed for.
Next matter, my lord, exactly, yes, same means, my lord, this order, only case number and the order date will be different. Same party. My lord, this order may be taken note of.
Why?
This is the same direction, same party, same response.
No, we're not passing any
No,
mentioning.
I'm praying for closing of the matter.
Same order.
My lord.
This is same.
Obliged.
May I please your lordship?
Yes.
The contempt in lordship?
So you have served the copy.
No, lordship.
Then
So the first.
no. Have you served the order of the this
Yes.
court?
Yes, lordship.
When?
At page number 15.
15.
Annex 2.
What is the receipt?
At page number 16. 15 and 16. Annex 2.
Where is the receipt? Where is the receipt?
15, lordship.
No. This is your letter forwarding of certified copy. Where's the receipt?
Annex
Wait.
2. Annex 2, lordship.
Okay. Annexure 2 is what? Where's the receipt? Copy to the commissioner. Have you submit?
Yes, the seal is here.
Receipt is not there. Where is receipt?
Lordship.
From where we can say that the respondents have received the certificate
The
copy?
seals.
Page 16.
15. 15.
Okay. Heard MS Financial and Counsel for the petitioner. It is an application under section. What is this? 12, 11 and 12 of the Contempt of Court agreed with section 15 of Constitution and Rule 3 of the Contempt of Court section. So, alleging violation of alleging willful disobedience and violation of order dated 15/05/21 in the issue notice so and so. Internal by 4 weeks.
Item 5.
Same order. So and so issue notice, Mr.
And Alam.
Alam, so and so. You just
Item 6.
Lordship, also for the matter for the time being.
what is this?
Ms. Bhattacharya is engaged in other court.
It's okay. We'll issue notice. That's all. You show us that you have served the copy. I've submitted the copy before the authority.
Lordship.
Where it is? Where it is? So and so. Same order. Issue notice. Return in 4 weeks.
Obliged.
Item 7.
Yes.
But in this case, my lord, there is a subsequent development, my lord. They have cancelled my work order, my lord. So, my
So,
lord, I may be allowed to withdraw, my lord. To divert it to file.
Mr.
Yes, okay, my lord.
S. Hockland, counsel for the petition submits that he may be allowed to withdraw his petition with the liberty to advise.
Item number 10.
As allowed, list, the accordingly resistance, the disposal on withdrawal with the liberty as prayed for. Item 10 also?
My lord.
Yes, same order.
File. Obliged, my lord.
Huh. Yes, sir. What is this?
My lord, this is against the cancellation of allotment, my lord.
Hmm.
In industrial estate of Bamuni Museum, I was allotted a space and open space.
Hmm.
In 1990, and
Hmm.
since then, my lord, it is continuing.
Huh.
And because of inflated, the hike of the rent, my lord, we approached this honorable court in 2002, my lord.
Hmm.
And this was decided by this honorable court.
Hmm.
Your lordship will find annexure 4 page 40.
Hmm.
This is the judgment earlier passed.
Where it is?
Page 40, my lord.
40. Huh. Yes.
My lord, in this case, it was, my lord, it was remanded back to the government, my lord, for a fresh decision, my lord, considering the computation of the rent, my lord, the fresh rent, my lord. And your lordship may kindly see page 64, my lord.
64.
64, my lord. There is a discussion regarding this, my lord. During pendency of the instant proceeding, a proposal was made by the corporation for incorporating a built in provision in the lease deed of annual increase of rent by 5%. In the meantime, respondents were made before the government as well by the allottees entrepreneur seeking its intervention for its reconsideration of the issue for enhancement.
So what do we want now?
Regarding rent, now the rent has been fixed, after 2004, your lordship may kindly say annexure 5. It is earlier 15 page 72.
Now it has been enhanced to
said rent 3.60 per square foot. And the open space 1.1.
now this has been
Now
enhanced to
during pendency of this, another after disposal of the writ petition, this was fixed by the government, and then another writ petition was filed challenging this, and after filing of the writ petition, during pendency of the writ petition, the three-party sitting was done with the young entrepreneurs of the industrial estate, plus
tell us motion stays. What do you want now?
stay of the cancel is now.
Not can stay. What do you want now? Which order you are challenging? Are you challenging some order?
Yes,
Which one? Tell us.
Annexure 18, page 106,
106. Come to that, no, sir. 106. This is what?
This is cancellation of the allotment, and with a treating, that there will be taken possession will be taken over, So we have challenged this, because there was a minus in between among
there is a outstanding dues.
Yes, these outstanding dues, because of this,
We acknowledge the receipt of
already
your response to the so-called issue to you as reportable. While we note that you have proposed to settle the dues by paying compromise amount of 50 lakhs.
unless
We regret to inform you that this proposal cannot be
according to them,
taken board of directors in its study by meeting alone. It was resolved that concerning units remain non-functional. Yes.
this amount is with compound interest of 18%. And
In that case, will stay this. Will stay the thereafter. What will happen? You'll be removed. You'll have to vacate.
Yes,
You'll have to vacate.
Yeah.
Will stay subject to payment of 50% of 99 lakhs.
No, already, after the minus, according to them, we offered 50 lakhs,
50 lakhs you
10 lakhs,
deposit.
10 lakhs already.
50 lakhs you deposit.
10 lakhs we have paid, 10 lakhs we have paid, and if 50 lakhs, your lordship may kindly say we have given a short,
It's okay, sir. It's okay.
If it is.
We are issuing notice, but then you have to deposit for stay of this
Matlab,
50 lakhs.
50 lakhs.
You are ready to pay 50 lakhs
Already 10 lakhs we have paid, Malade. 9 lakhs something, Malade, we have paid, Malade.
out of 50 lakhs.
Out of 50 lakhs.
Rest amount you pay, you deposit. Subject to deposit of rest amount will stay.
I'm submitting before your lordship may pay it and accept 20, it is the calculation. If, Malad,
It's okay, we'll see, we'll give them an
only-
opportunity.
only 28 lakhs is due, Malad.
Sir, we're issuing notice, you deposit, will stay this, stay the, you should not be evicted. Subject to payment of 50 lakhs.
50 lakhs, already 10 lakhs we have paid, Malad.
It's okay, you
Malad-
deposit 40 lakhs.
Malad, a lesser amount maybe.
No.
Malad,
Because you are ready to pay 50 lakhs.
at least 2 months time I will require, Malad. Otherwise, Malad,
We'll stay this, but then subject to deposit.
Malad, if immediately we have to pay, Malad, it is sick unit, Malad.
We cannot help it.
At least 2 months, Malad.
Sir, we have to balance.
At least 2 months, your lordship.
It's not that the petitioner files a petition. At the drop of hat, we grant the stay. No,
For this
we'll have to balance. Yes, Mr. Samaria.
Rightly pointed out.
Deposit. You are ready to deposit 50 lakhs.
Government money.
Time factor, my lord, I am not saying, my lord, we will not deposit, but at least 2 months time maybe.
No. We'll stay subject to deposit. You may deposit. If you don't deposit,
We are ready, my lord, within a time period.
10 days.
10 days, my lord, it is impossible on our part, my lord.
You are ready to deposit. You are ready to deposit.
10 days, my lord,
Heard Mr. D. Chaudhary.
at least what?
It's up to you.
10
Let us
days-
be very clear.
10 days will be very.
Then 15 days. 15 days.
1 month, my lord.
15 days.
30 days, my lord.
Sir, 50 days.
30
15 days. 15 days.
30 days, my lord, at
No.
least if you.
Lordship, may I submit, Lordship,
Yes.
only one thing, that this petition otherwise not maintainable in the eyes of.
We'll see.
That only, I'm prima facie, my lord.
Yes.
Reason is that, my lord, that there is a provision for appeal which they have already exhausted.
Huh.
That appeal is pending, Lordship, kindly see, that contained in page. Lordship, against this cancellation order, they have preferred a representation before the authority, page 107, Lordship. Just I'm just putting on only one thing.
Mhm.
107 is the representation which is pending, which is the form of appeal,
Mm.
and that appeal is provided under our policy, my lord.
Mm.
Till that no decision has been adopted.
It's policy.
Therefore, Lordship,
We'll see. You decide before.
Absolutely.
In the
Therefore, Lordship,
pendency, during pendency, you may decide.
exactly, my lord, there is no dispute to that effect.
Ah.
Lordship, 50 lakhs is, my lord, reasonable amount because there is a huge liability,
Yes,
public
yes.
money, my lord.
my lord,
50 lakhs in the sense he has already deposited
What if
10,
that will
10
be
lakhs.
adjusted, my lord?
Huh.
If suppose deposit, that will be adjusted, that no. my
We'll
lord-
say 50 lakhs minus the
deposited.
amount already deposited.
Yes, my lord. That
Yes.
observation is.
30 days time maybe. going to.
15 days, sir,
My lord,
15 days.
will be.
Heard Mr. D. Chaudhary, learned counsel for the petitioner. Challenge made in this writ petition is to the order that the communication that is 07/08/2025 issued by the managing director AIIDC. What is AIDC?
My lord,
Infrastructure development program.
my lord, we are respondent number 3 and 4, my lord.
Respond number,
3 and 4,
who is this managing director?
my lord.
Respondent number?
3 and 4, my lord. The notice has been issued by respondent number 4.
Managing director AIDC. Whereby the proposal for payment of 50 lakhs against the total outstanding amount of rupees 29 lakhs 26,461 has been rejected in view of the decision taken by the Board of Directors dated 26/03/2025 with a further direction to vacate and hand over peaceful possession of the allotted space of the petitioner to AIDC within 15 days. This is 7th August. 15 days is also over. Today is what?
Yeah, yeah.
From today, my lord.
From today.
Today is okay.
Yes, that may be effective from today, 15 days.
Okay. Please stop. It is the contents of the petitioner that as per the tripartite agreement,
Sitting.
settlement,
Yes.
settlement, the petitioner is ready to pay 50 lakhs, out of which an amount of 19 lakhs,
About 9
and
lakhs.
about 19 lakhs and odd,
19, not 19, 9 lakhs.
9 lakhs and odd has already been paid.
Subject to verification.
List of,
Yes.
It is, my lord, that-
is to issue notice returnable by 4 weeks. As Mr. Who is the state?
One and two.
Mr.
SR Burwa.
SR Barwa, Land State Council for Respondent number 1 and 2. And and Mr. S. Samaria, Land Standing Council,
Yes, sir, 3 and
Standing Council for all the respondents, enters appearance. No, enters appearance on behalf of all the rest, no formal notice been notice will be served. However, extra copies be furnished to the council for the respondents. Next paragraph. Considering that the petitioner is in possession of the space,
Yes.
yes, ma'am.
allotted to the space allotted since how many years?
It's long, my lord, since long.
Since many years, and is willing to willing to deposit 50 lakhs
Deducting the
Yes.
amount paid already.
by deducting the amount already paid within a period of 15 days, in the interim, it is provided that the communication that internal communication that 0708/2025 shall not be given effect to.
My lord, only
It
one
is made
observation-
clear that
Yes,
the petitioner shall, the interim order is subject to the payment of 50 lakhs minus the amount which is stated to have been deposited,
subject to verification, my lord.
which is subject to verification within 15 days.
Yes, ma'am.
Uh,
Failing
else-
which, my lord,
else-
we'll proceed.
Failing which the
We may be allowed
order,
to proceed.
interim order shall stand automatically vacated. Not- Yes,
First, them appeared in the board list of 2005 for the first time.
So, it's a devoter matter on similar terms.
same order, you find out. Heard Mr. So-and-so and consequence so-and-so. You're Mr.?
Yeah, yeah, lordship.
Yeah.
Respond number 2.
Respond.
Standing on the election.
SR Burwa for respond
Ah.
number 4.
Do you agree?
Yes.
We'll,
Yes,
same,
yes,
we'll send it to have a verification by the SP.
Yes, Lord.
SP board, Same order which you passed by, you just find out. But, name kya order there? Victory, day for yesterday.
I submitted that order, lordship.
Huh.
The particular order I have submitted.
Huh.
Therefore,
Mm. You just. Yes, disposed of.
Make clear, your lord.
Yes, sir.
My lord, here, my lord, we have challenged the termination letter. And
Lease agreement,
yes, my lord.
where it is
It is at page 55, my lord.
55. They don't want you, you're the owner of the building.
Yes, my lord.
So,
My lord, what happened, my lord? They took the second floor and third floor for 10 years.
so
After completion of 4 years, my
what
lord,
does agreement says?
my lord, agreement is at page, my lord, 21, my lord.
Page 21. Any clause
My lord,
or,
my lord, kindly come to page 24,
hmm,
bottom portion, my lord. The last but
one line,
Hmm.
passageway and hereinafter called demise premises to hold the same and with all easements and other apparatus unto
The
the
for-
lease
the
for
for-
10 years from the date of handing over position of the demise premises on 1st of July 2021.
Hmm.
Agreement was executed on 10/12/2021 and they took possession before that execution of the agreement from 1st July 2021.
After 4 years now,
After
is there any provision? Any clause to say that they can?
My lord, the agreement was made by them in one-sided manner.
It's okay, you have signed it, you are
Yes, my
relying
lord,
on this.
yes,
Where it
my
is,
lord.
where is that clause? What is that
That
clause?
clause is at page 32, my lord.
32, yes. What does it say?
Roman 3, my lord.
Yes.
Notwithstanding anything to the contrary herein before, contain lesser
Shall have
as
the
well as
option to
lesser
terminate lease
cases.
at any time, giving 3 calendar months prior notice, and after the period to be mentioned in such notice, this lease shall cease to be. Yes.
Now, my lord,
Notice has been given.
notice.
It is a notice.
That is, I'm
Like to-
challenging that termination notice, my lord.
Huh?
My lord,
Sir, it's a matter of it's a breach of it's a purely breach of contract.
my lord, I am relying your lordship judgment, my lord.
What?
Wherein your my lord, state has to act fairly. My lord, I have kindly consider one thing, my lord. I have invested several lakhs of rupees, my lord, for accommodating the bank, my lord. It's a construction and all, my lord. Yeah, I rely your lordship judgment, page 32. Paragraph 32, my lord.
It's a tender matter.
My lord, here, my lord, also termination of lease, my lord.
Termination of tender.
My lord. And
Contract. Termination of contract.
contract.
That is something different. This is the termination of lease.
Termination of
And
lease.
it's clearly provided as page 32 on giving 1 month, 3 months notice.
3 months notice.
So-
my lord, only consideration, my lord, we have invested so much amount for accommodating the bank.
But-
It's a
Your agreement, the lease agreement clearly
My lord.
shows that
No,
it
my
can be
lord.
terminated by giving 3 months notice.
That's why I
So-
prefer your lordship, my lord. Why, my lord? Because the agreement was subsequent to the handing over the position. I have no alternative, my lord. I have to sign that because they took the premises on first of July 21, and they executed the agreement in the month of December 21, my lord. After 5 months, my lord.
You have signed this agreement.
My lord, I have to sign, my lord.
This deed you have signed. There is a clause clearly shows
My
that.
lord,
Is there
Mhm.
any violation of this contract,
my lord,
lease agreement?
yes, my lord, they took the premises for 10 years.
It's all right.
That is legitimate expectation.
It is only for 10 years, and there is a clause providing that there can be the option is being to terminate at any time on giving 3 months calendar months notice, prior notice. That has been done.
My lord,
Or if you are claiming that there is a violation of the contract agreement or the lease agreement, you approach the civil court.
my lord, at least 2 months time to file. 2 months time, my lord. Let me.
Sir Basia, I don't have to say, you know more than me.
My lord, at least
It's
some.
purely civil dispute, please.
My lord, there is no disputed facts, man.
Huh?
There is absolutely no disputed facts, my
Then
lord.
there's no wrong.
My lord,
There's no wrong. There's no illegality.
my-
They have acted as per the lease agreement terms of the. That's all.
my lord, on that, my lord, I am relying a Supreme Court judgment, 2004. Yes. Yeah.
On what? Saying
My lord,
what?
My lord,
It's all settled.
it is not acted fairly, my lord.
It's all settled position of law.
My lord, yes.
You saw us that it has not been the bank has not acted fairly.
My lord,
See, you have entered into a lease agreement.
my lord.
Where there is a clear clause to giving option either of the party to terminate the lease by issuing by prior notice of 3 months. That has been done. Matter ends there.
My lord, only thing, my lord, I have invested so much of.
What can I do? That's what I'm saying. Your doors are not closed. You may seek,
lord-
I don't have to advise you. I mean,
My lord,
suggest you.
That is there, my lord.
Sir, better to withdraw.
My lord, only this, my lord, termination notice was given for 3 months. It will end on 11/9, my lord.
So,
At least 1 month time, my lord,
No.
to approve the civil code. My lord. That much your lordship is.
No, no, no. We-
Of equity, my lord.
prima facie, not prima facie. I'm clear, maybe I'm wrong in the interpretation, understanding of the law. I'm clear
No,
that it's
I'm
not,
saying
the
that,
rate
my lord.
petition is not maintainable at all.
My lord, I'm not saying that, my lord.
And you are not, I mean, stopped from availing the appropriate remedy.
I'll do
Better.
that, my lord, sometime maybe.
Let, I mean, your good sense and the knowledge prevail.
My lord, let sometime maybe given, my
No.
lord, to approve the civil code.
When it will expire?
On 11/9, my lord.
11/9.
My lord.
You have enough time.
My lord,
You have enough time.
only 11 days, my lord. Let it be at least 1 month time, my lord.
Cannot be.
I leave it to your lordship.
No, I cannot.
If my lord is exercising the jurisdiction of equity, my lord. My lord,
It's a pure and simple contract. It's a pure and simple contract.
my lord.
Lease agreement between you and the bank.
But,
And I don't see any
but
wrong.
the bank is state.
There is
it's
no
a state, my lord.
question of equity, sir. I'm not saying that it's not, they are not state or the authorities under the act, under clause Article 12. I'm not saying so.
My lord,
What I'm saying is a pure and simple contract. If you alleging any violation, remedy lies somewhere else, please.
my lord, that is understood. Understood.
Heard Mr. G. Bashir, learned counsel for the petitioner, who fairly submits that he may be allowed to withdraw this writ petition with the liberty to approach to avail the appropriate remedy as may be permissible under the law. Please stop. Prayer is allowed. Or should I dismiss on
No, my lord.
merit? Prayer is allowed. Accordingly, writ petition stands clause on withdrawal with the liberty as faithful. This stuff. That's all.
1 month time is not good. All right.
Doctor, the petitioner is a religious institution, Your Honor.
Yes.
For the new construction of the said institution, the petitioner is seeking some permission.
No,
from the
this,
authority. That is banned. That is banned.
If it's
So
banned, if it's banned, cannot help it out. Huh?
Only page 10.
Page 10.
Page 10. Some institution is still, that practice is going on, Your Honor. Page 10 only.
No, if somebody is doing it illegally, say there is no concept of negative
Yeah.
equality under article. Article 14 doesn't envisage negative equality.
But because it is banned, we are already leaving in our application, that is banned. But let a representative maybe.
No. How can we say, how can direct them to consider consider the case by violating the rules?
Those petitions were still pending. The stay was there.
No, sir, it's not permissible. It is, if it is banned, it's banned.
I guess. We should really also. Because our represent never being answered by the authority.
No, it's okay.
Banned.
No, if it is
That much-
banned, if it is banned, it's banned.
But authority
It's a
was-
gambling. It's a gambling only. Maybe for a good cause, but
Positive.
ultimately, the income may go to the good cause, but then to earn that, it's a gambling only. If it is banned, it's
Somebody is
banned.
still running.
That I said,
Page
there's
10
no
itself.
concept of negative equality.
They openly say-
It's always positive. That you know. So withdraw. Or-
We may again approach the authority. Authority say that. This
No,
is
no,
bad.
we cannot do that. Even if authorities allowed you, it will be illegal. It will be illegal that we. So withdraw. And Mr. Arpish Hazrika,
Yes.
learned counsel for the petitioner, who fairly submits that he may be allowed to withdraw the writ petition, as the writ petition pertains to as the matter relates to seeking permission to conduct lottery, which is banned in the state of Assam. Therefore, withdrawal is accepted. Accordingly, writ petition stands closed. As Mr. Bigo, so and so. Addition, you record all this. Addition and doing are present, huh? Sorry, sir. Yes,
Yeah, my lord, in the instant case, however, my lord, this is a contract, my lord,
yes.
or my lord, carrying my lord, PR van, my lord, for the period of 5 years, my lord, and 260 days, my lord. Round trip was 260 days. Before 5 years, my tender was terminated by
Yes,
them.
yes.
And after termination of the tender, my lord, we approached before the authority, my lord, stating that there are two periods. There is a condition of 21.1. If they are failed to provide the, my lord, vehicle, my lord, railway van, then this period will call as a dice down. 16-month period was.
Well, just issue notice.
Yes, sir.
No interim, nothing. No interim, nothing.
Otherwise, Lordship, the contract period is over in
Well, stay, you say whatever, what just prove it.
Lordship.
And Mr. NNB Chaudhary, learned counsel for the petitioner. Next, by filing this writ petition, the petitioner has prayed for a direction to allow the petitioner to run and register the parcel ban number 515601, 1560, Purbattar Sampark Granti Soinsa, page 19. After extension, issue notice returnable by 4 weeks, as Mr. So-and-so. SS Roy.
Lordship.
And then standing counsel, CGC. CGC, enter appearance. We have all the respondents, no formal notice. Over extra copies. Huh?
Obliged.
Yes.
This matter pertains to payment of contractual dues. Lordship, the
For construction of what?
Lordship, construction of a bypass in North Lakhimpur district of Assam.
Yes.
Now, Lordship, the fact of the case is that, Lordship, in the year 2012, the contract work was awarded in favor of the respondent number 6. Now,
That
subsequently,
is construction of bypass of Lakhimpur,
North Lakhimpur.
not Lakhimpur. It is, it's our daily
Lordship.
hometown road.
Lordship. Lordship, the work.
Why you are not paying?
Lordship, the
Lordship, may I?
We are also indirectly affected.
Lordship, I went to the writ petition, Lordship. Lordship, this is a case, Lordship, where the petitioner is a subcontractor under the main contractor. The contract was
So
allowed.
you are saying that the payment should be directly in your name. You are a subcontractor.
Lordship, I am a subcontractor.
That cannot be. There must be some agreement.
So otherwise, definitely this honorable court will not pass any such direction. So my submission at this stage, Lordship, to address his grievance, Lordship. One representation is there at page 47, Lordship.
Is it?
One Lordship,
Page-
page 47.
Page 47.
Yes.
Because the original contractor has disappeared from this signal.
So let this matter be remanded back to the authority, Lordship. Let the authority consider this representation by giving due hearing to the other side also
Okay.
and decide this matter, Lordship.
Agree.
That can be done. That representation is pending.
Because you know, you cannot directly
And
ask the payment because you are the subcontractor. There must be some agreement.
There is an agreement. Lordship, which
Otherwise,
has
he
been
has done the work, Lordship.
Ah.
That is admitted, Lordship.
Oh. Okay.
Dispose.
Heard Mr.
A. Chakraborty, Lordship.
Learned counsel for the petition. And also heard Mr. P. Naik,
I'm
learned
preparing for 1 to 5, Lordship.
Additional Advocate General.
Yes, Lordship.
for respondent 1 to 5. Who is 6?
The six.
Okay, there is a one private respondent. What
This is
can
the
we?
other party, Lordship.
Huh?
The main contractor.
Main contract. So
Respondent.
Lordship will say, any decision
By hearing.
to be taken by hearing this person only.
Okay. Having considered, no, in view of the order proposed to be passed within bracket intra bracket clause, comma, this writ petition is taken up for disposal at the motion stage without issuing notice to the party, without issuing notice to the respondent number 6, as the order would not cause any prejudice to the respondent number 6. Next paragraph. Petitioner, no, filing this writ petition, next paragraph, the petitioner has prayed for a direction to pay an outstanding amount of rupees 12 crore,
Lordship,
12 crore 50 lakhs in respect of the balance work of construction of proposed North Lakhimpur bypass from existing kilometer 338/924 to kilometer 349/213 of National Highway in the state of Assam, within bracket zone number so and so, page 17, directly to the bank account of the petitioner, as the petitioner has executed the work as a subcontractor. List of next paragraph. Petitioner is a registered contractor, what? Registered firm,
Lordship.
Registered firm whose principal place of business is at North Lakhimpur, Assam. List of pursuant to the NIT dated pursuant to the NIT in the year 2012 for construction of proposed construction of North Lakhimpur bypass from existing kilometer 33/924 to kilometer same, in the state of Assam. Job number, package number, so and so, para 2. The work was, the contract work was awarded in favor of one MSDRA, DRA TKEE within bracket JB bracket clause, joint venture of Dinesh Chandra Agarwal Infracom Private Limited, Ahmedabad, and TK Engineering Enterprises, comma, respondent 6 hearing. The petitioner, Mr. Hauber, no, you said for a contract value of rupees 95 crore 89 lakhs 14,270. Mr. The contract was terminated.
Contract was terminated.
Mr. Hauber, due to certain issues, the contract awarded to the respondent number 6 was terminated by an order dated 05/08/2020. Will not record all other this other details, when you were awarded.
But the MOU is dated 11/1/2021.
No, which, no, not MOU.
Lordship, the direction was, Lordship, if Lordship kindly comes to page 21. The authorities had directed that a suitable working partner should be engaged, and accordingly I was engaged. Page
No,
21.
that's 21.
21, Lordship.
Thereafter, next para, huh? Thereafter, 21.
Page 28, consequential is page 21. Page 20, consequential is page 21. Page 20 is the direction by the Undersecretary, Lordship. If I may read it, Lordship, second paragraph.
No, when you were awarded the contract.
Lordship, I was engaged as a working partner under the original contractor, Lordship.
Okay.
In terms of this letter.
Page 20.
Page 20, Lordship. May I read it, Lordship?
List of,
Lordship.
no, it's okay.
Lordship.
The government of Assam, the authorities to the government of Assam in the public works within bracket highway department by an order dated 28, by a communication dated 28/1/2020 to the chief engineer PWD within bracket NH works, bracket close. How you were engaged?
Lordship.
Page 21.
Lordship, page 20, the termination order was revoked subject to the contractor engaged and willing working partner.
Has accepted the proposal for revocation of the termination order against the respondent number 6 in view of the observation of this court. In WPC what?
Lordship, WPC number is Lordship 3214 of 2020.
WPC 3214 of 2020.
Lordship.
Where we're providing another chance to complete the work.
Lordship, the second paragraph will be relevant, Lordship. The approval is, however, subject to the contractor engaging a credible willing working partner. Under this circumstance, I was engaged.
Where it is?
Lordship, page 20, second paragraph, Lordship. This approval is, however, subject to the...
How about the approval was subject to contractors engaging a credible willing working partner capable of infusing adequate resources in the project with demonstration of satisfactory proportionate progress.
In terms of the same, the MOU at page 22 was executed.
In terms of the above, in terms of the said communication, page
22, Lordship.
A memorandum of understanding was entered into between you are Vishal Bajaj.
Lordship, I am the proprietor of the petitioner firm.
The respondent number 6 and the petitioner by dated 11/01/2021. Next paragraph. Mr. So and so learned counsel for the petitioner submits that on being entered into entered into a memorandum of understanding dated 11/01/2021 between the respondent number 6 and the petitioner. The petitioner has executed the work and completed the work of construction of so and so, you just said.
The work completion certificate is at page 46, issued by the authority.
Page 36.
46, Lordship.
46. The work the completion certificate, work completion certificate of balance work was also issued by the executive engineer PWD, Nagav National Highway Division, Nagav. List of. He submits that although the petitioner has completed the balance work with the to the satisfaction of the authorities, the respondents have failed to pay the amount of rupees so and so, 12 lakhs, 12 crores so and so, directly to the petitioner. List of. Therefore, submits the direction may be issued to the respondent authorities to release the payment of so and so to the petitioner. Next paragraph. Mr. P. Then additional advocacy for the respondents submits that although the petitioner has completed the work of so and so, it does. It is not discernible whether the payment should be directly released to the petitioner or to the original
Main contractor.
or the main contractor, as the petitioner has already has executed work as a subcontractor.
Working partner. Also.
Huh?
Working partner.
Working partner. And wherever we said that
Subcontractor. Yes.
subcontractor, you said working partner. Huh? Mr. Therefore, he submits that the representation filed by the petitioner may be directed to be disposed of after hearing the petitioner and the respondent 6 as per the MOU or other MOU and other provisions in the contract agreement. Mr. Next paragraph. Having considered that the petitioner has admittedly completed the work of so and so, however, payment has not been released to the petitioner. And also considering that the petitioner is a working partner of the main contractor within bracket and the respondent number 6, comma, and the memorandum of understanding and other contract agreement has not been, is not placed before this comma. I deem it appropriate to dispose of the writ petition with a direction to the respondent authority. Who will decide?
If respondent number 2.
Respondent
Given to the respondent number 2.
Respondent number 2 to take up the representation of the petitioner dated representation dated 11/04/2025 of the petitioner and to dispose of them the same Mr. Accordingly, the petition is disposed of with a direction to the respondent authorities, particularly respondent number 2, to dispose of the representation dated 11/04/2025 after hearing the petitioner as well as respondent number 6 list of in the event the respondent number is found to be entitled, comma, the amount entitled to be paid to the amount of rupees so and so, either directly or to the main contractor, comma, same shall be released. In the event of, released. You consider the representation within 1 month.
Yes.
1 month.
Yes, no.
Thereafter, in the event, if it's thereafter 1 month, within 2 months.
No, that lordship may not say.
No,
Within 1 month, lordship will dispose of them.
Thereafter, in the event, if it is found that they are entitled, either to directly to the petitioner or the main contractor, you release within 1 month thereafter. Petition this 1 month.
Oblige. Like that. Let me watch.
Yes.
Lordship of kindly said page 63. Here the bid of the petitioner was cancelled on the ground that he, along with some another firm, Lordship, uploaded the documents for the bid from the same internet connection.
53.
63, 263. Lordship.
263. Yes.
This is to the reference to the bid submitted against the subject matter as per the records available on the GEM portal. It has been observed that the technical bids of the MSG2 in the Energy Field Service, Shivsagar, and MSG2 Enterprise Sound Service, Shivsagar, were uploaded from the same IP address, so and so. This is viewed as being in contravention of the provisions of Section 2 of the Integrity Pact and amounts to non-compliance with BEC clause number B2G4G of the tender. Accordingly, the offer has been rejected.
Yes.
Merely because the same internet connection was used. Because when Wi-Fi connectivity is used, Lordship, generally if two or more devices are connected to the same Wi-Fi connection, then one IP address will be shown. And that itself cannot be, Lordship, in my humble subject, cannot be termed as a Lordship. That
They will issue notice.
Otherwise, Lordship, they will finalize the tender.
Well, they will say subject to outcome.
I'm paying
Hard,
for
Mr.
sale also.
And I will not mistake. This is for what?
For Lordship, hiring of service that
Where is this tender?
tender also start from page page number 29.
Yes. Custom bid for services, hiring of services, mud handling and other miscellaneous jobs with unskilled manpower for drilling service and occasional assault. This is the one.
Lordship.
This is the job.
This is the job.
Okay. Heard Mr. So-and-so learned counsel for the petitioner. The challenge made in this petition is to the made is to the technical evaluation history that is 25 12/08/2025, whereby the bid of the petitioner, technical bid of the petitioner has been rejected on the ground of on being found in contravention of the provisions of Section 2 of the Integrity Pact and non-compliance with BEC clause number B2.2.4 within bracket G bracket clause of the tender. Page 263, page 263, pursuant to the what is this? NIT? NIT or what? NIT dated 25/06/2025 for custom bid for services dash hiring of services to mud handling and other miscellaneous jobs with unskilled manpower for drilling services, Ankleshwar asset, Tripura asset and Assam asset. Page 29. Issue notice returnable by 4 weeks.
I'm paying for respondent number 1 only.
Who is for ONGC?
When panel is there, my lord, I have to put panel.
Have you served a notice?
Notice
ONG was implemented by this court only?
Notice as they do not accept the copy.
No, you should have given to them. You have not.
I have approached, but they said after you.
Unless, okay. Actually, issue notice returnable 4 weeks. Mr. B. Datta. A.K. Datta. Learner CJC. Enters appearance on behalf of respondent number 1 only. Respondent number 1. No formation notice be issued. The petitioners to take a stage for service of notice upon respondent 1 to
8.
128. Oil and natural gas engine company, huh? 128 by register post so and so, huh? That's all. Subject to outcome is always there.
That may be observed in the order.
It has not been finalized.
It has not been finalized now. The
The-
final award is not, final contract has not been
the-
awarded.
Tender process. The finalization of the tender process when questions shall be subject to outcome of the present petition. That's
Problem.
53.
There is an order which has been passed by the authority whereby I am agreed by the order where we decided to demolish my third and fourth floor, which your lordship will find at page 52. 52.
It has been demolished.
No, it has not been demolished. What they have done, I just tell your lordship, 2003 and 4, NOC has been issued, but not in respect of third and fourth floor. Ground first and second. If your lordship looks into the NOC at page 28, 28, kindly see, my lord, 28. 28 is respect of first, ground first and second. Please look into page 28, my lord. Then I will, 28.
Just wait.
Yes, lordship got it.
Where is the procedure for this is the order
Orders of the
appellate authority.
Appellate authority.
Okay.
Now again that we have come up before this course, order of the appellate authority. But I told that I have gone through it. There is another provision, my lord, where you have to prefer an appeal for the state government also. But I find. But this we have come up before this court. And my lord, the whole issue is about the unauthorized construction, which I find is third and fourth floor. Now I have asked my client, so far as fourth floor is concerned, they will do it. One house is, one room is there. He has given assurance that he will do of his own. Ground floor also, with the help of the GMC, there were some shops which are built. We decided also to remove that, and accordingly it has been removed. Only remaining third floor. Now third floor, whether it can be regularized, subject to regulation, because there is a bylaw which is now it is up to the government whether they can. In the appellate forum, they said we can't regularize this. Now it's up to the state government whether there are cases, my lord, where suppose you.
So under the act, there is the appeal provision. Further appeal, second appeal or something like that.
State government, my lord, there is a provision.
You approach them.
Yes. Now what I will do, my lord, we'll approach that, my lord. But some protection regarding third floor should be given every 10 days. We'll approach the state government.
No, sir. If there is a provision of appeal or second appeal to the appropriate authority, they have the power to pass the interim order also.
No, what I am saying.
Why you should accept the power of the authority under the act?
What I am saying, that if this is done, tomorrow if they go ahead, nothing remains in my case.
That's what I'm saying.
That is what.
I'm raising if there is a provision for appeal, further appeal.
I said, my lord, there is a provision.
That's what I'm saying. That's why
I dealt the case yesterday. I thought I have to point out before the.
Yes, that's why.
There is a provision.
That's why on your pointing out, fair pointing out.
I have to point out. My
Yes.
senior counsel, I have to point out.
That's why.
Yes, but there has to be some, my lord, equity where protection can be given. Your lordship is not so powerless.
Sir,
I am not asking something, your lordship, that some protection, at least for 5 days, 10 days, we can have. It's a matter where he considered 2003-4. 2004 he completed, my lord. There may be some mistake, but there is a process.
procedure for regulation, my lord. That's why I'm saying, my lord, there are procedure. Maybe the appellate forum has said that, no, sorry, we can't regularize. If the state government can, my lord, that's what I'm asking, my lord. Some equity, my lord, demand equity. I'm asking for equity.
Yes, sir.
5 days, my lord. Only.
You also kindly be fair enough.
Yes, lot of demolition order was issued.
Correct.
Yes.
Against that, one appeal was prepared. That appeal was dismissed. Another case is pending, filed by the
Petitioner.
not by the present petitioner, lordship. He is an occupant of that building, lord.
My lord, I have sold him first floor, 1 unit. He is making all this complaint. I sold him first
On the basis of that complaint, lordship, this court passed specific direction why you are not taking action in terms of the demolition order. So we proceed. In the meantime, lordship, the present petitioner has also given undertaking. That within such and such time, we are going to demolish of our own. So one portion he has demolished. Remaining portion, lordship, third floor and fourth floor, lordship.
Fourth floor also is ready to
do it. I told my
Undertaking is they are now saying. And so far as the appeal provision against the appellate order passed by the appellate authority, that probably lordship, my learned senior colleague will enlighten us, which is the provision.
438. My lord will kindly see. 438 kindly see. 438.
Which that is?
The GMC Act.
GMC Act.
Kindly there is one book. Same page. It is proposal. An appeal to the right to state government division of service and hearing council. 438. 438. About these things to limitation as
Copy to 26.6 on the next question.
My lord, kindly see 438 of the at page 175. What you got it? 175.
Yes.
Kindly see appeal from commissioner to mayor in council. If your lordship looks into my appeal, it is mayor in council where we prefer an appeal. Earlier to standing committee, now is mayor in council. If you please go further, provide notwithstanding anything contained during an appeal shall lie before the state against the decision of mayor in council.
Yes.
So there is a provision where an appeal has to be filed from the state government. Within 30 days, but there is a limitation also. Now pursuing, because we received the copy only 26/6/2025. Because there was a matter before the High Court by one of the person who we have sold that 1 unit. He came to the High Court. And he said, why demolition is not being carried out? My appeal was pending, no order was passed, and thereafter we received on 26/6/2025. We received very late. So that is why we are approaching.
But you have taken, you have given undertaking
Yes,
here.
fourth floor I will do.
In the month of July itself.
Yes, sir, correct.
There is one undertaking.
And we have already.
Where is that undertaking?
Undertaking is not in record law.
Not on record.
I have copy law.
Well, it's a fact. Let us admit, my lord, it's a fact that ground floor there were some shops which we cleared with the help of GMC. I told the client at fourth floor you have to clear it. Third floor, 1 unit has been sold to one of the party. 1 unit is on rent. Now this whether it can be regularized by the government or not. Appellate body said that no, we can't do it. Now it is in the hand of the state government. So give us 1 week time, we will approach the government, man. So far as third floor is concerned.
It should be within 1 month.
Yes, correct. Correct, my lord. And we received on
The order was of 13/5.
No, 13, no.
Yes.
My lord, the appeal was filed. Appeal was filed by us. Kindly, if you see the appeal, was 9/1/2025.
No, the appeal, the order Other challenge is of 13/5/2005.
We were not aware of it. We came to know when. Your lordship will kindly see at page 50. Kindly see page 51. Some third party has filed his petition where I sold at page 50. Lordship got it, page 50. It is filed by one Sanjay Sharma where I sold one of the unit to him. Now kindly see at page 51. Now, which has been dismissed the appeal file. Response number 3, rejecting his application for regulation so and so. It was not intimated to us. Only we came to know by virtue of that petition. Now we made a statement. Kindly see. Paragraph.
Now, this is by the GMC.
Yes.
Unauthorized tax sales will be prayer for regulation.
Yes.
It doesn't talk about the appeal.
I'm sorry.
It doesn't talk about the appeal.
No, I know. The appeal has been filed.
Yes.
Appeal has been filed. His application
Thereafter, what happened?
rejection. No,
It
my
was
lord.
rejected.
Rejected.
No. On 18th, when it was, matter was fixed on 18/7, there must be some order.
Meantime, we received last instruction on lordship.
The petition will come to my dispute of the petition after certain lordship.
Lordship, this was the instruction we received after the last order, 18/7. 26, 18/7, yeah?
This writ petition is pending.
That is
Pending.
They say they were already demolished.
Which one? Third floor has not been demolished.
The unauthorized construction as mentioned in the order dated so and so, that is 13/12/2024, has been demolished on 19 August.
That is, my lord, there are ground floor where that was demolished. Ground floor. But so far as the third and fourth floor is concerned, my lord, that is not being demolished. Fourth, we will do of our own. Third is an issue where my lord will kindly see.
Have you filed this affidavit in the writ petition?
Initially we filed, but this instruction has not yet been incorporated.
You are incorporating this 4562.
It is placed for an order. It is not yet placed.
That is filed by a separate party.
No, we'll
Yes.
list along with this writ petition.
Paragraph 14 kindly be seen, my lord, of my writ petition at page 16. Paragraph 14.
Sorry.
That it is stated, lordship got it. Paragraph 14. That it is stated WPC 4562 of 2012 preferred by Sri Sanjay Sharma came for consideration before this on 26/6/2025 and the concerned counsel for the GMC informed Honorable the Appellate Authority in GMC dismissed the appeal of the petitioner, rejected his application for regulation of authorized construction by the order dated 13/5/2025. Petitioner came to know about dismissal of his appeal only after such information furnished by concerned departmental counsel. Prior to that, petitioner did not have any information about the appellate authority dismissal order dated 13/5/2025. Though the petitioner approached the concerned office of the appellate authority from time to time, inquire about the outcome of the appeal, and he has never been informed about dismissal of order dated 13/5/2025. We were not aware of it. Some third party where I have sold, he comes to the court and he complains about this unauthorized construction. Then only when this petition was presented by the third party, then only we came to know. Because my learned friend's client by GMC has said already we have rejected their appeal. That is why specific statement has been made in para 14.
Hearing is not required or what? In the appeal?
No, hearing was there.
Hearing
No,
was
hearing-
heard, Lordship.
Hearing
Both sides-
is there. Hearing is required. Hearing is done. It is not an expertise.
No, that's why I'm saying once you have heard, it's very strange to,
No.
that you don't have the knowledge of dismissal of the appeal.
Which No, it was heard, they did not, my lord, our whole case, they did not communicate to us the order. My lord, they did not communicate the order. Appeal was heard, they did not communicate. That is what our petition is.
Jahrul Islam.
Yes.
New JB complex.
Yes. 2003-4 I constructed my lord. 4 constructed, assessment.
Heard
tax
Mr. Didas, learned senior counsel assisted by learned counsel for the petitioner. Challenge made in this writ petition is to the order dated 13/05/2025 passed by the mayor in council within bracket appeal Guwahati Municipal Corporation, Guwahati, by which the appeal filed by the petitioner has been dismissed, and direction was with a direction to the authorities to proceed to demolish the unauthorized construction of the petitioner. List of it is contended by learned senior counsel Mr. Didas that although the appellant the petitioner was heard in person, however, the order dated the impugned order has not been communicated to the petitioner. List of the petitioner came to the order dismissal of the impugned the dismissal of the impugned dismissal order dated 13/05/2025 has been brought to the knowledge of the petitioner by one Sri Sanjay Sharma.
Yes.
Where is that order?
That page 50. 50.
Sanjay Sharma, who is a writ petitioner in WPC 4562 of 2024. Filed against you, filed against the GMC and the petitioner. You are here. You are a party here.
Yes, yes. That's not true.
Against the state authorities as well as the petitioner for demolition of the unauthorized structure. List of Mr. Learned senior counsel has also fairly contended that although the writ petition has been filed against the impugned order dated 13/05/2005 against passed by the mayor and council, there is a provision. As per the provision of section 438 of what is this? Guwahati Municipal Corporation Act 1971 provides for an appeal. Before the state government against the decision of the mayor and council. Therefore, at this stage, he submits that the petitioner may be granted a week's time to file appropriate appeal in terms of the above provision. List of issue notice returnable by 3 weeks. As Mr. You are appearing for all.
Yes, Lord.
P. Nayak, learned additional advocate. Additional advocate general, or you are a
Additional legal officer, I am appearing for all the.
additional advocate general? For all the respond, no formal notice in this hour. So next one. Considering that the regulation as permission, considering that the petitioner's request for regulation of the unauthorized structure has been rejected by the respondent authorities, and finally by the Impleadment order dated 13/05/2025, carefully depict that there is a provision for appeal before the
Lordship will once again go through this provision, Lordship.
What he's saying, that separately I can file an application before the state government. Separately, and they can call for the records. As there may be no provision for the appeal, he said there is a provision where we can directly file before the state government, and the state government, if necessary, they will call for the records. That's what it says about 428.
Otherwise, the decision of the mayor in council is final, Lordship. That is there.
We can come to the court, that again. But there is a provision for a separate application before the state government, where they can call for the
then we'll
records.
say that next para, considering that then we read those grievance with regard to regulation for unauthorized structure by the petitioner has been rejected by the authorities. And also considering the related matter being WPC, connected matter being WPC 4562 of 2024 is pending before this court, till the returnable date.
Lord, that matter is listed on 5th, Lord.
5th.
Yes, 5th of September.
We'll say till the returnable date.
Yes.
We'll take along this.
Both matters are coming together.
Then issue notice returnable by 5th, so and so 9, Then you said till returnable date. Impute order so and so. Change shall not be given effect.
Lordship will also observe that he has already given undertaking that 4th floor he will demolish himself. So far as regularization is concerned, only in respect of the 3rd floor.
Please stop. It is informed. It is further stated by the in view of the submissions of the learned additional AG that the petitioner has already given an undertaking to demolish the
Today, Lordship, in the petition,
what we
demolish
said,
the
4th floor will clear whatever.
that undertaking. Undertaking
Fourth
given by the
floor will
council.
clear
of the
it.
petition.
please stop. Then since the petitioner has undertaken to demolish the 4th floor and ground floor.
The ground floor is done. Ground floor is done.
No, except the
3rd floor.
3rd floor. What is to be then?
Lordship, so far as the protection your Lordship has granted, that will be only in respect of 3rd floor.
Then
In the meantime, you will demolish the 4th floor.
of the 3rd floor shall not be given effect to, except in respect of 3rd floor
Yes.
only.
The 4th
As
floor
the
will be demolished by
the
petitioner.
petitioner has undertaken to demolish the 3rd floor, 4th floor and the ground floor. List along with the WPC so and so.
No, the ground floor already we have done it. That's
If you have done, it's done, it's okay.
No, your Lordship, again they will come, again they will do it. That's with the help of the DMC we have done. But there was some shop we have
No,
removed.
you are saying that it's already removed.
Yes, so
If
your
not
Lordship,
already demolished.
it already is done, my Lord. That's why I'm saying they will come and they will demolish something else. Because virtue, so my Lord
No,
will.
it is, I think, what is to be demolished? Entire building is unauthorized structure.
No, it's not entire. Ground floor, 1st and 2nd floor is, they have given permission.
Some portion in the ground floor.
No, is given
plus
permission.
3rd and 4th. That is
Okay.
unauthorized.
Well, ground and 1st, 2nd is permissible. They have given NOC. Entire building is not an unauthorized mile. So at least ground floor, we have done it. So we putting it there, so again, they will get some, no, we'll go and again, we'll do.
He's there.
They should not, my Lord. That's why I'm saying. That they should not do it, my Lord. That's why your Lordship.
No, once you have already done, they'll not come and do it. They'll not do that.
That's your lordship was saying again, ground floor will be removed by them.
Then you said that port accept the undertaking to demolish the fourth floor
Yes.
and the some parts of the ground floor has already been demolished.
Definitely. I am deeply obliged.
I may change the order later. You
Have to.
let me apply my mind.
Please,
You will get
my
it.
lord-
You will get it in the evening.
my lord, you please change it, no problem, but don't change.
Because I thought I'll provide you a week's time to prayed by you to file an appeal. He said that they
No, no.
cannot be appealed.
No, what I'm saying, my lord.
According to it's either it's a prevalent proceeding. I mean, kind of
So far as the
prevalent power
so far as the provision is concerned,
proviso.
yes.
What does it say?
430. On page 176.
This is
A
a
notice
interpretation.
for other action taken or delivered to be taken by under any action. So
Say second, my lord.
any
176.
casualty
176.
under any refusal commissioner grant a license. If any
Provision
any
two
such
lordship
in full
second paragraph.
compliance of rules allowable for the timing for
The decision of the
council
mayor in
reverses
council.
substantially modifies the orders are proposed to be taken by commissioner or any other board by May within 60 days of the corporation pending decision by government.
If you
When
see
the matter has been referred to the corporation.
10(3)
decision will be proposed shall be filed. The decision and evaluation provided that the notwithstanding anything contained in this act during the period of suspension. Supersession. What do you mean by during the period of supersession?
No, you please go behind that. After that, notwithstanding anything contained in the principal act. Lordship got it? Notwithstanding anything in the principal act, state government may anytime call for the records of any matter from the corporation, give such order as may be deemed necessary after examination of such record. Order of the state government in this regard shall be final. So we can file a separate application before the government.
That is,
That is, my lord.
No, I mean, provided the notwithstanding anything contained in the act, I'm talking about the proviso.
Lordship,
During the period of supersession, what do you mean by supersession?
Lordship, kindly see second paragraph of 2. The decision of the mayor in council or where the matter has been referred to the corporation as aforesaid, the decision of the corporation shall be final. But that is the subject to lordship.
If the decision is violation of rules and regulations for the time being enforced, then the commission shall refer the matter to government.
So
Then,
that is not applicable here, lordship, because
then
we are following. But 10(3) may be applicable, lordship, but this is not.
Well,
as an
you see, provided that the notwithstanding anything contained in the act during the period of supersession, what do you mean by this? During the period of supersession, and an appeal shall lie before the state government against the decision of the mayor and chief, mayor and council.
Because earlier there was a standing committee. Now it has been replaced by mayor in council.
No, sir. What do you mean by during the period of supersession? Supersession means what?
Supersession in respect, maybe my lord, if you see 438. Because standing committee, there was a standing committee which has been replaced by mayor in council. So during that period, supersession period of supersession and appeals are live before the state government against the decision of the mayor in council.
No, during the pendency of the appeal. But to my understanding, lordship, if during the period, lordship, when the appeal is pending, if any decision is taken by as a interim decision, lordship, by the mayor and council.
So there is no, there cannot be any appeal, according to you.
There cannot be appeal to the state government, but
Against the order of the mayor and
council. Separate application can be filed.
So we'll change that. Or should I keep it your submission? You said there's a provision appeal against the mayor and council.
No, what I find is if you lordship see.
Now things have to change.
Now 10(3), it appears, is my right.
Sometime we may maybe.
No,
wrong.
we'll delete that, huh?
Yes.
I'll just correct it.
Yes.
I will not record that
Person has
one.
already issued notice.
Yes.
Notice.
Yeah, that's, your submission will
Yes.
delete it,
Yes, yes,
except the factual one.
yes, yes.
Appeal part, I will delete it, huh? That appeal part, submission of appeal part, you just delete it. Okay, we'll correct it.
Yes, I am deeply obliged.
Yes,
Eight pleasure.
yes.
We were the petitioner,
Huh.
and we had got a stay.
Hmm,
When we got the stay relying on Lord's own order
hmm.
in a different writ petition. So we have to file an objection under the stay petition.
Okay, we'll give them a chance. Heard Mr. Kejriwal, SK Kejriwal, learned counsel for the applicant. This is an application for praying for modification. What is here? Praying for vacation, modification and or oblique or alteration of the interim order dated 24/03/2020 passed in WPC number 1626 of 2025. List of. You have already received.
Yes, I have received the copy.
Notice need not be issued.
No, notice was not issued.
Even the office of the ombudsman is also represented. I have served a copy below.
Is he a party?
Yes, Mrs. Because
You have already accepted the notice
Yes, I have already accepted notice.
on the prayer of Mr.
SP Sharma, madam.
S.V. Sharma, learned counsel for the writ petition, opposite party of the writ petitioner. 2 weeks time is granted to file objection to the IA. Both, you want to also file, Mr. So and so is present.
The judgment copy is there, ma'am. The ones from Lord's
You
own
take,
judgment.
you take it back,
Aviraj Hatch.
Abhiraz.
26.
Item 16.
Lordship.
Yes,
This matter pertains to allotment of IOCL petrol pump lordship.
yes.
My candidature was cancelled only because I could not upload the land details lordship.
So
on
matter
time.
ends there. You could not upload.
Yes, lordship.
Matter ends there. Matter ends there.
Hence their lordship.
So?
No, then that's why I am before the lordship, because that time I was actually suffering from COVID lordship.
Very.
And that time lordship actually there.
Is it
was
as
some-
per the terms of the condition of the allotment?
There are conditions, lordship, but one thing, lordship.
Your rejection is as per the terms of the condition, I mean, terms and condition of the
That-
voucher or the
telling
policy.
certain
Guideline.
guidelines are there, but these are the lordship, this was an unusual circumstances. At that time, the petitioner, he was also suffering from COVID and there was also election and all these things. Anyway, lordship, I am not on that. I
You are
have
no,
served
anyway, don't press.
no, lordship. I just want to obtain certain instruction from my kind. Lordship may fix any date next week, lordship.
my lord.
So on that
Anyway,
date, I will
we'll
appraise,
give you
lordship.
10 days time.
10 days is not required,
Check,
lordship.
my lord, what we are offering is that they can approach the IOCL separately also. On this subject matter, my senior friend has said that she needs some instruction. My lord.
Yes,
The matter
lordship,
can be
on that
closed in
particular-
direction. Next week, my lord, a short date may be given. The matter.
Yes, lordship, on 4th or 5th,
It has
lordship.
already been allotted to some other person.
No, this
No.
has not been allotted,
In
lordship.
fact,
That's
as we
why.
understand, since
Hmm.
there were no valid applicants,
Hmm.
group 1, group 2, the petitioner falls.
There's
into
any
group
interim order.
three. There's no.
No, lordship, no interim order was there.
Hard MS
M.
Bhattacharya, learned counsel for the petition, not hard, MS M. Bhattacharya, learned counsel for the petitioner submits that she may be granted a week's time to obtain instruction as the petitioner may not like to pursue this matter.
No,
Is it the-
lordship, not that, lordship, because I have to
Because
talk to him, lordship.
because there is no merit in this writ petition.
To talk to him, lordship.
Then instructs from the petitioner, huh? Praise the Lord, so and so, huh? Mr.
M. Sharma, my
M.
lord.
Sharma
That's one
is
for
present
2%.
for
2%.
respondents, huh? List after a week.
Lordship, date may be fixed, Lordship, on 5th.
Will be dismissed. So
Lordship,
don't
this
press,
is separate,
don't,
Lordship,
don't press,
regarding fixing Lordship.
don't press. This will be dismissed. After 1 week, it will be listed.
Lordship. Deeply obliged.
Grateful, my lord.
Item 17.
Lordship,
Yes,
here in this case, Lordship, I have to file an affidavit, Lordship.
it's been fourth or fifth time.
No, Lordship.
I mean, this is today's third time. You check up the order.
Lordship, I think this first time, Lordship.
Second day.
Second.
Third, fourth.
also.
See, 24-3 is directed to
Fix
file
the matter.
affidavit on behalf of
Yes,
respondent 1 and
fix
2.
The matter, Lordship.
Then 28-3, then 30, 4. Today's fourth.
Lordship, kindly fix the matter in the next week, any date, Lordship, I will file.
You know that very smart. You know that there are so many matters fixed in the next week.
Lordship, any date, Lordship.
After 2 weeks,
Lordship,
as a last chance.
Lordship, Lordship,
Today is fourth.
Lordship.
Third, MS
Lordship,
P.
Lordship,
Bhattacharya,
Lordship.
learned counsel for the petitioner. As a last chance,
Lordship,
on the prayer
I
of
will
Mr.
definitely file.
Mr.
Lordship, I will
J.K. Goswami, learned state counsel, is
Lordship,
granted
Lord-
2 weeks time to file
Lordship,
affidavit as
Lordship,
directed by this court.
I will definitely
Mr. Ah.
file, Lordship. I will definitely
Who
file.
has assured that
But last time, Lordship, last sons.
he will definitely file.
Yes, but last sons may not be there. I will definitely file, Lordship, but last sons may not be because.
If you are definitely filing, what?
I will file, Lordship. I will file, Lordship. In the last occasion, I was, I think I was not. present.
Granted 2 weeks time to
Yes.
file affidavit
Yes.
as directed to this court on last 3 occasions
Lordship.
as a last chance.
The last sons may not be, Lordship. Last.
No, last chance. We have heard enough of this
Lordship,
matter.
I will.
Ah,
Phone number 456.
so and so,
Keep order.
they were present for this.
456.
456. 18, 19,
Yes, Lordship.
20,
21.
21, 22.
This matters come.
Yes. Why you are no affidavit? You just take instruction.
From the division, they are saying that fund demand is not there. So, my lord, I would suggest let the chief engineer verify, my lord, and
Yes, Lord.
then payment can be initiated, my lord, in
Within 3 months.
3 months.
You pay within 3 months. All right. Dispose of. Item
18 to
18 to
22.
22. Within 3 months. Within 1 month you verify. Thereafter, within 2 months you make a payment.
Very
Release the amount. What is the work you have executed?
Lordship, there are separate work orders. Some for, the first petitioner is there for Lanka Revenue Circle,
Ah.
Bordolong.
First we'll dictate. Then we will list. Heard MS Beach or learn counsel for the petitioner, and also heard Mr. Borthakur. Learned counsel for the standing counsel.
Hello.
Learned standing counsel for all the respondents. Account officer, PHE, all the respondents, all the learned standing counsel, PHED for all the respondents.
Lordship, similarly situated persons were here before your lordship.
Okay.
And the case has been disposed of. After a verification exercise was done.
Same,
Yes, Lord.
then it's okay. Same. You just, the name of the work and the name of this thing. Huh? Why unnecessary spend time?
Yes, sir. Much
Yes.
better.
3 weeks, 3 months, huh? First, within 1 week, you verify, and thereafter, if found admitted and entitled, pay within another 2 months. Okay,
That amount which is not admitted, for that I shall have the.
that's it's always open.
Yes, Lord.
Disputed amount, you can always avail the other remedy. Huh? It's only admitted amount.
Yes, Lord.
Maybe Mr. Bortakur may suggest them, you just dispute it. Anyway,
Much better.
it's on letter vein, letter note. Yes,
Lordship, I take your lordship to page number.
what is the matter, sir?
Matter lordship, petitioner's fair price license was cancelled by the authority.
What
Fair-
license?
Fair price of license,
Okay.
lordship.
Hmm.
He, against that cancellation order, he preferred an appeal. Appellate authority also upheld the order passed by the
Yes.
lordship, order passed by the.
So what's wrong?
Lordship.
We have not, what do you call? You have your, these articles were seized. You have not distributed.
But there is a order, lordship, it should be distributed in between 9th to 15th of each month. It was seized on 8th.
It has been already cancelled.
Lordship, the
Affidavit has been filed.
lordship.
Okay.
Affidavit
Or
filed.
Mr. So-and-so, learned counsel for the petitioner. And Miss MS Udas, learned state counsel for all the respondents. Pleadings are complete. Writ petition is admit the petition, list for hearing after 2 weeks.
A date maybe.
After 2 weeks.
Any date, lordship, otherwise it will be.
It will be listed any day after 2 weeks.
May it please, your lordship.
Yes.
So in this case, today I am filing my affidavit in reply against the affidavit of respondent.
On the prayer of Mr. So-and-so, learned counsel for the, Mr. So-and-so, learned counsel for Kandahar, learned counsel for the petitioner submits that he would be filing his affidavit in reply. He is filing the additional affidavit in reply during the course of the day. Therefore, fresh for listing of the matter after 3 weeks. MS so-and-so, learned counsel for the petitioner, learned counsel for the respondent is present. You also, you write all your are present, huh? List after
2 weeks.
3 weeks. 3 weeks.
2 weeks. Fine.
3 weeks. Why?
That's a bit.
Then 2 weeks. Then 2 weeks. Why 3 weeks? Huh?
Just now I have received a reply, so I'll go ahead.
You have to take instruction. 2 weeks is enough. 2.5 weeks. Anyway, 3 weeks.
Finally, my lord, 2 weeks.
3 weeks. Huh.
Problems.
May please, your lordship.
Yes.
Matter relates to lordship non-payment of outstanding dues. Lordship earlier noted. Respondent number 1 has already filed affidavit and has filed reply, lordship. The affidavit of respondent number 2 is very much required, lordship.
Okay. The petitioner respect completion of work. Yes. Who has to pay?
As per respondent number 1, lordship, respondent number 2.
But it's a peculiar contract actually.
Okay.
Where the fund had actually come from the ministry to construct the athletic track. Now that fund was given directly to the North Lakhimpur College. To execute that work, they had employed us through a separate agreement. So we are an agency who floated the contract on 7% contract charge money.
Okay.
Now the bills are paid by the North Lakhimpur College through us to the contractor.
Okay.
Some additional work was done for which budgetary approval was not there. And since North Lakhimpur College is not paying us, we in turn cannot pay to the contractor.
Respondent number 3, the ministry, my instruction is this. The entire sanction amount of rupees 5.5 crore
Was released.
Yes, we released to
So-
college. Yes, to the college.
We'll have to catch him.
Yes, sir.
He's the one who is, not you, the college is the one who is creating a mess. Okay. Heard MS P. Bhattacharya, learned counsel for the petitioner. You have filed the affidavit.
My lord, I have filed.
Mr. B. Phatak, learned counsel for respondent number 1. One submits that he has already filed the affidavit in opposition. On the prayer of Mr. Learned counsel for respondent number and
about 3 months.
further 2 weeks time is granted to file affidavit in opposition.
It's a date, Lordship.
We'll see
After
after
2
2
weeks,
weeks.
Lordship, any day.
Can you file within 2 weeks? Can you file within 2 weeks? We'll give you a time to adjust. And wherever you have misplaced or mismanaged, you recover and pay them.
We'll take instance about that. It's 3 weeks, because not Lakhimpur College is not.
3 weeks.
A date may be fixed.
Just give the date,
Yes.
3 weeks. Appears you have mismanaged somewhere. Once the amount is released by the ministry, there's something wrong. Anyway.
Actually, my lord, there's no mismanagement also probably. What had happened is that only the athletic track was sanctioned.
Okay.
But then the track without a UV coating would not last.
Okay.
So that UV coating was to be added as an extra item.
Okay.
Without that, there was no purpose of the track, my lord. All 5.6 crores would have gone waste, my lord.
Okay.
So that additional budget, my lord, has not come.
Okay.
That is the
Okay.
difficulty.
Item 26.
Non-payment.
Non-payment, my lord.
Yes. So you'll pay. Yes.
Yes, ma'am.
How many?
One petitioner, my lord. One petitioner.
How many?
The
Within how many days?
Lordship, 3 weeks.
3 weeks. Heard Mr. N.J. Kathinia, learned counsel for the petitioner, and also heard MS
H. Terangpi, your Lordship.
for
All the respondent.
all the respondent, learned counsel. Yeah, standing counsel.
No,
No,
Lordship, on behalf of S. Nyogi.
learned counsel for all the respondent. We'll see. By filing this writ petition, the petitioner has prayed for direction to the respondent authorities for payment of an outstanding amount of how many? How much?
4 lakhs, my lord.
4 lakhs.
Total amount is 10 lakhs, out of which 6 lakhs has already been paid, my lord.
For 4 lakhs, huh? Outstanding balance amount of rupees 4 lakhs for the on account of the execution of work of construction of market shed at Garmari serially allotted to the construction committee by the order dated 26/03/2018. List of. It is the contention of the petitioner. The contention made by Mr. N.J. Kathinia, learned counsel for the petition, that the petitioner pursuant to the resolution passed by the EY Autonomous Council, several orders were issued by the respondent number 2 to the construction committee for completion of various construction works during the period construction works in the year 2018. The petitioner, being the president of the construction committee, was allotted to the work of construction of Market Shed and Garmari Seriali with an estimated cost of rupees 10 lakhs. Out of the sanctioned amount of rupees 10 lakhs, an amount of 6 lakhs was released as a first installment. However, the remaining 4 lakhs has not been released as yet. Therefore, prays for release of the remaining outstanding amount of 4 lakhs to the petitioner. Next para. MS Terang Pit so and so learn counsel for the respondents on instruction fairly submitted that the amount claimed by the petitioner is an amount of rupees 4 lakhs is a balance amount of total sanction amount of rupees 10 lakhs for construction so and so. The petitioner in fact has executed their work with the full satisfaction of the authorities. She submits that the respondent authorities shall release the admitted amount of rupees 4 lakhs to the petitioner within a period of 3 weeks.
No, your lordship can be within 1 month.
Within a period of 30 days. From today.
The receiver.
No. From today. You'll get the certificate copy in the evening. From today. This stuff. Having considered that the font and having considered that the petitioner has executed the executed the works of what the construction of Market Shed at Garmari Chariali to the satisfaction of the petition, the respondent authorities, and the claim amount of rupees 4 lakhs is an admitted amount coupled with the submission of learned state council that the admitted amount shall be released within a period of 1 month from 1 month, I deem it appropriate to allow this petition with the direction to the respondent authorities to release the admitted amount. Accordingly, the petition states dispose of with a direction to the respondent authorities to release the admitted amount of rupees 4 lakhs to the petitioner within a period of 1 month, 30 days from today. Same.
Item 27 is also
Same.
but their amount is total amount is 5 lakhs
5 lakhs.
and balance amount is 2 lakhs.
2 lakhs. That's all.
Okay.
And the area construction is
Name of the construction, construction of boundary wall at Filamari LP School.
construction of boundary
Wall
at
Filamari LP School.
Pilamari School. You are also president of the construction
Yes,
committee.
Yes, ma'am.
You just say. Don't mix it up, Second was construction boundary wall. Yes.
Obliged.
This was the.
Team 29.
Yes.
Again, my lord, admitted outstanding liability.
Yes.
Verify and payments.
Yes. Heard Mr.
Yes, sir, my lord.
S. Sharma, learned counsel for the petitioner. One petitioner.
One petitioner.
This application is filed for action to the respondent authorities to release the outstanding dues of the petitioner amounting to rupees 12,42,714. So 2015, sir.
15 to 7, they have admitted the liability that, and reply is they have admitted. And they are supposed to. file
This
the
is for
affidavit.
what?
My lord, kindly see page.
No, construction of what? On execution of.
Works, my lord. Lordship, kindly see the page 45 to 47.
It's okay. Various works of what?
My lord, renovation of, my lord, drain at the chief engineer of PAC office, public health engineering.
Where do we get it?
My lord, will find page 23 to 44, there are 19 work orders.
Page 40?
23.
Page 23.
Page 23 to 44.
23.
My lord.
For execution of various works, including installation of 100 mm dia air bulb to 250 mm dia. You just read page 23 to 45.
44.
No, various work executed by the petitioner. Under the Department of Public Health Engineering. List of next paragraph. The art so and I bought you filed the affidavit. You have filed the affidavit.
They have admitted, my lord. Kindly see the page 47.
47.
My lord. The amount has been, they have admitted.
Liability statement of Sri Pramod Kumar Chaudhary. By whom? Executive engineer.
My lord.
Chief engineer will have to verify, my lord.
And lordship will kindly see page.
Anyway, we'll dispose it of.
Yes.
To verify and so. The petitioner claims to be a registered contractor of class 1C category under the Assam Public Works within bracket Building Department. First of, he has been awarded. This is by way of work orders.
Various work orders.
Not NIT.
Not work orders.
The petitioner was awarded various works of which are as follows by way of work orders which are as follows. Page 23 to 45. Name of the works. You find page 23 to 25. Who is respondent number 3?
Superintendent.
By the Department of Public Health Engineering. And by the Department of PhD, Government of Assam. It is the next paragraph. Contention of the petitioners that he has executed a total numbers of contract works, total 19 numbers of contract works, and completed the same executed the total number of 19 numbers of contract works to the satisfaction of the respondent authorities. However, the a total outstanding amount of rupees 12,42,714 has not been released as yet. List of release as yet despite repeated approaches. List of the petitioner and list of therefore phrase that direction may be issued to the responding authorities to release the admitted outstanding amount of rupees so and so to the petitioner. Mr. I. Bortakulan Counsel for the Standing Counsel PhD on his clearly submits that the writ petition can be disposed of with a direction to the concerned respondent to verify the claim of the petitioner and to make payment in the event the claims of the petitioner is admitted. This the next paragraph. Having considered the submissions of learned counsel for the parties and also on perusal of the Annexure 21, that is page 45, showing the liability statement of petitioner is under the signature of executive engineer, Guwahati PHE, bracket close PHE, Guwahati division number 2, and the accounts officer PHE, comma. I deem it appropriate to dispose of the writ petition with the direction to the respondent authority to verify the claim of the petitioner. And in the event, if the claim of the petitioner is found to be admitted, same may be paid to the petitioner. Next paragraph. Accordingly, writ petition. No, accordingly, it is directed that the respondent, that authorities, particularly
Chief engineer.
Chief Engineer, PHE. This is what Chief Engineer is only, there is only one Chief Engineer.
Chief engineer water. Second water.
Respondent
Respondent number
authorities,
two.
respondent authority, particularly
Two.
the Chief Engineer, Public Health Engineering, a PHE within bracket water, shall verify the claim of the petitioner within the period of 1 month from today. In the event, if the claim of the petitioner is found to be admitted, same shall be released to the petitioner within period of 2 weeks.
3 months.
3 weeks. Sorry, no, 2 months.
2 months.
First 1 month, then within 2 months, if it's found admitted, Yes.
Another matter is 32 and 33, same, my lord.
32 and 33.
My lord.
This is what? Same
Again,
work.
Same PHE, public health engineering.
Same work.
Different work, but under the PHE.
Work orders.
Yes, yes.
Where is the work orders?
My lord, now, my lord, 32. It's for page 24.
Page 24 only.
24 to 37.
24 to 37. You just take down the name of the works,
I will provide them, my lord.
And 33?
33 is page 24 to 26.
24 to 26.
Amount is defined, my lord.
Amount will be different.
I will give them.
In 32, what is the amount?
7,22,468.
Then 23?
6,84,023.
You just mention. The name of the works you just mentioned and the amount will be changed. Same.
You provide me.
Yes.
Oblige.
His associates. Yes.
Admitted amount, my lord, affidavit has been filed, my lord.
Okay.
They have admitted, my lord, that work has already been.
Affidavit and filer of PWD, they have admitted that that amount is due and they have paid it. Other 50% will be paid by the Department of Housing and that is the affidavit, my lord. I will get the interest rate instruction, my lord. I am paying for the Department of Housing and Urban Affairs also. I have not received the final instruction, my lord.
You take the instruction
Yes, sir,
next week. We'll fix it next week.
Lordship will give me 2 weeks time, my lord.
Is it?
2 weeks time.
It's very difficult to take instruction.
It need times, man.
Heard Mr. So-and-so learned counsel to the petitioner. G. Alam,
Yes, my lord.
learned counsel for the petitioner. Mr.
As per respond number,
As per learned standing counsel for housing and urban affairs.
as well as GMD,
Huh?
as well as GMD.
As well as GMD submits that. Phrase for and is granted 2 weeks time to obtain instruction as regard the payment of, as regard the payments of other 50%.
Not 50%, my lord, the
50% amount
Remaining amount, my lord.
remaining amount.
as regards the remaining amounts claimed by the petitioner.
Yes.
Huh?
Yes, ma'am. May I clear the date, my lord? Because
Let's
any date,
see.
my lord, document.
Well, it's 2 weeks, it will be listed.
Yes, my lord.
What is the amount?
My lord is 48 lakhs, my lord.
It's too big. We'll give them another 4 weeks.
My lord.
2 weeks, huh?
Yes, my date, any, my lord, date, anything.
We'll see after 2 weeks. It's an obtain instruction only.
Not sure. I need to file on affidavit also.
No, it's okay. You obtain instruction. Within 2 weeks is enough. Give the date.
17, na?
Huh.
Okay, oblige. Oblige.
One question हो जाए.
The tender issue for settlement of 2 gates.
हाँ.
And for 1 gate, they have given the settlement.
हाँ.
And for the other matter, they have given short tender notice. After opening of my tender,
हाँ.
after seeing my bids, the question is whether this can be done. Well, I'll just take your lordships to the facts. Your lordship will kindly see page 18.
Can we dispose of this today?
Very short matter, Malad, it's an urgent because the settlement period is lessening every day, man.
There's an interim order.
No, but the period of settlement was for particular up to December. And if it is, if the petitioner is allowed to have it, we will have it only 4 months only.
Lordship, petitioner have filed affidavit in reply. We have received instruction to that reply of Lordship. We would like to file rejoinder to the.
No, what is the question of reason? There should be never ending. Is there is he taken any new ground?
Some new facts have
No,
been
no,
brought.
no,
You
no
folk.
ground. Well, I'm on the basis of their records only.
Let them, we'll take it up next week. Next week.
Lordship.
You just go through and find out if there's nothing. I mean, this cannot be allowed. Again, you will file a reply to it. Again, they'll say,
I have just brought the facts. The last year it was 50 lakhs.
now it is.
Now, then thereafter they have settled it for 1 crore. 1 crore. And I have quoted 1 crore 53, so 43 lakhs. And their rate was 75 lakhs. So both of them, both for the Mandadesa and the Detoxera gates, the tender was issued, value was 75 lakhs each.
We'll see next.
Detoxera was settled, but mine was cancelled after opening of the tender.
This is page 18 is what?
Page 18 is first settlement notice.
Please to settle the right for regulation of entity so and so. Huh?
This is in respect of this market. This vehicle gate, my lord. And this was set aside by the court on the ground that no notice was issued. No NIT was closed. So thereafter, my lord, this High Court has set aside this at page 19. And thereafter, they have floated this tender at page 27. On the basis of this tender, my lord, your lordship will kindly see the value quoted for Mandadesa vehicle gate is 75 lakh 37. And for Detoxera gate is only 75 lakhs. So the petitioner has quoted about 1 crore 43 lakhs that your lordship will get it at page 31. Page 31.
Your monkey chant ho jaye.
Yes. He has quoted 42. Now, after opening up
1 lakh 43.
Yes.
1 crore 40.
1 crore 43. So now after opening up the tender, they have issued the short tender notice again in respect of this Detoxera vehicle gate.
Same.
But in respect of the others, they have settled it.
So you are challenging the short note, sender note.
Short notice, yes.
Whether your this has been, what about your this thing? They have rejected your tender, I mean,
No, they have not
offer.
rejected that.
They have not done anything.
In affidavit, they are saying the other gate, they have settled it for 5 crores some amount, but The day after.
The earlier tender was not cancelled.
Earlier tender was not cancelled.
Earlier tender has been cancelled and subsequently fresh tender has been issued, Your Honor.
By this
And they have
short.
not been barred. Petitioner have not been barred to participate in the fresh tender, Your Honor.
No, no. How can you first this since
Earlier tender was not cancelled.
is it your stand?
Earlier tender has been cancelled and our stand is like.
He said it's not. Learned Senior Counsel has said it's not been.
They have just issued a short tender. Page 34.
Since or since so and so is prevails by the instruction by the authority for the right of collection of anti-tax on entry of vehicle. Is it permissible or the right of anti-tax?
See, my lord, after opening of the tender, they cannot do it.
Only-
Unless they have a very good reasons. And the reason has to be recorded. It has to be shown in public. Now public knows my price.
The
Okay,
right
that's-
of collection of anti-tax on entry of vehicle at detoxera vehicle get at the official value of rupees 1 crore
1 crore.
only for the period. He has quoted 1.43.
43. Also.
Your value is 1 crore.
1 crore.
We are expecting the higher revenue for that purpose that re-tender.
Then why don't you make it 2 crore?
5 crores. No.
Huh?
Because the petition, the
The issue is, if there's a reason to cancel it, you may not be, you cannot say that you cannot cancel, but there must be something you have, first initially, you have issued a tender
Lordship,
and the petitioner has participated. It's quite a reasonable, rate.
and they've opened it.
Lordship,
They will open it.
Lordship, may peruse my affidavit in opposition, page number 46.
So we'll take it up
It's the
next week.
cancellation of-
You just go through the, whatever is there. And Mr.
Husband, sir, is in file.
BD does Learned Senior Counsel assisted by so and so Learned Counsel for the petition. On the prayer of Mr.
D1000 Lordship.
D1000 Learned Counsel for the respondents, a week's time is granted to go through the affidavit in reply filed by the petitioner. List after after a week.
The dates may be given, my lord.
After a week, it's very difficult. You just list it.
Next week, my lord.
After a week. We'll take it up after a week.
It will be Friday.
34.
Outline, Lordship.
34 is not over. 33 is over. Yes.
My lord, the matter pertains to non-payment of the contractual works, my lord, done by the petitioner, my lord.
Yes.
And the petitioner has annexed in respect of every work, my lord, the
Ah.
work order. For instance, my lord, if your lordship comes to annexure 1 at page 21, my lord.
They filed the affidavit.
No, my lord.
So this second time, this is listed for second time. What happened?
Lordship, we like to have instruction, Lordship.
The notice was issued way back in June.
The only thing is that, Lordship, we have received a copy, extra copy today only. So let us.
My lord, I admit, my lord, that was.
Okay.
sorry.
But Mr. DP Bora, Learned Counsel for the petitioner. If you are admitting, what can we do?
Yes, my lord, I understand.
I wanted to say something, but then you are admitting, so.
Yes, my lord.
On the prayer of
Talukdar,
Talukdar.
respondent numbers 1, 4 and 5.
Learned State Council.
State Council.
Further 2 weeks time is granted to obtain instruction and to file affidavit in opposition.
Lordship, let it be 3 weeks, Lordship. Because we have to file, after obtaining instruction, we have to file.
3 weeks.
3 weeks, Lordship.
35.
Obliged, my lord.
May I plead your lordship?
Yes.
Lordship, lordship will kindly pair us order dated 18/8/25. Your lordship.
Yes.
In pursuance of that order, we have filed a IA and additional affidavit, but it is not on record, your lordship.
Steps have been taken before this in terms of the section 14 of regulation. Yes, MS Swenso Learned Counsel for the petitioner said that as per direction of this court, as per the order of this court, that it's 13/08/2025, she has filed the additional affidavit.
And
However,
an impleading petition.
applications as well as additional, however, the same is not tagged with with the writ petition. Mr. So-and-so. Learned counsel for the respondent bank. Respondent bank is present. In view of the above, record, registered to verify and take the affidavit and the application and the affidavit, additional affidavit with the records, with the writ petition. List after 2 weeks.
Oblige.
36.
Item number 36, Lordship, I am seeking 2 weeks time to obtain instruction, Lordship. Instructions are still awaited in this matter, Lord.
Instructions were placed, your lordship, on the last occasion. They have sought time to file.
Yes, you have already obtained the instruction. You are supposed to file short affidavit.
Lordship may grant us 1 week's time, Lordship.
Heard MS.
D. Musahari, your lordship.
Maybe learned counsel for the petitioner. Although this court, on the prayer of learned state counsel on 01/08/2025, granted time to file short affidavit as they have already, as the respondents have already received the instruction. Mr. Learned state additional.
Appearing on behalf of Mr. Bigo is on leg, Lordship.
Learned state counsel pressed for and granted a week's time to file affidavit.
Oblige, your lordship.
Supplementary post, please. Petition item 55.
May please, your lordship. Will you kindly peruse the order dated
Yes.
20/7, my lord, 25. Please, your lordship. Lordship, in this matter, Mr. D. Gogoi learned additional AG appears, lordship. Let it be taken after some time. He is around, I will inform.
After some time.
After some time, lordship. Admitted amount to my lord. He was directed to obtain some instructions. Government repeatedly directed.
Yes, I have seen it.
after that, lord.
Yes.
Any questions on the item 37?
Lordship, in this case, I seek a week's time, Lordship. We'll have to implement the new.
On the prayer of Mr.
M. Das.
learned counsel for the respondent.
For a petition.
Petitioner. A week's time is granted to file appropriate application for impleadment. Yes.
39.
39. None appears for the petitioner on hold. It is noticed that this list of this contempt notice, contempt case is filed in the year 2018. It is noticed that on the last listing on 02/1/2024, none appears for the none had represented the petitioner. Mr. Considering above, the contempt petition stands closed. Disposed of. It stand closed as the as it appears that the petition may not survive. Huh? The petition, the matter is not survived.
41.
May I please your lordship, hearing this case for lordship, other income has been transferred, your lordship.
Huh?
Other income has been transferred. 1 week time may be began to file.
What is the order? Order.
Yes, lordship.
What is the order?
Ask for your lordship.
Which order has been alleged to have been violated?
Your lordship. Annexure.
Anything remains?
Yes, lordship. Annexure A, page 7, your lordship. Contempt petition, your lordship. This is the order.
In view of this, then the ultimate is in the
Authority
dispute
for-
whether is not in dispute, discord is incurred, allotted by directly respondent to release the payment of outstanding bill of
Yes,
rupees to ensure, huh?
Yes, lordship.
It has not been paid.
Not paid, your lordship.
On the prayer of so and so and counsel by the petitioner, further 2 weeks time is granted, not further, 2 weeks time granted for filing appropriate application for impleadment.
43.
All first will finish the orders.
Please, lordship.
Huh?
Lordship, the matter is lordship infectious, lordship.
Mr. So-and-so, land counsel for the petitioner. Your name, please?
Lordship, Jane Nabil, lordship. I'm on behalf of lordship A.Y. Chaudhary, lordship.
So-and-so, land counsel appearing by A.Y. Chaudhary. Land counsel for the petitioner submits that the matter has become infructuous. Accordingly, the writ petition stands dismissed as infructuous.
44.
In this case, I'm appealing for respondent number 2, 3, and 4.
Yes.
For
So,
this time may be granted for filing reply.
ah,
For this time may be given for filing reply.
and Mr. So-and-so, Mr. So-and-so, on the
K.
prayer of so-and-so, KL,
KL Gupta.
K.
KL Gupta.
KL Gupta, land counsel appearing on land counsel for the respondent number
2, 3, and 4.
2, 3, and 4 is for phrase for and is granted 3 weeks time to file affidavit in opposition. Yes. 3 weeks, 3 weeks.
7.
May I please, your lordship. The application filed for restoration of content is dropped on 16/7/2025. Annexer page 2, annexer page 13. Lordship, when after the date of engaged counsel, the matter was listed on 22/3/2024. Then the junior counsel appeared and took time to file implement petition, but the implement petition could not file because there is communication gap. And thereafter, the matter was listed on 16/7/2025. Then the engaged counsel not appeared because the engaged counsel was suffering from some diseases like abscess in fissures and hemorrhoids, and he was admitted in hospital, lordship. Thereafter, doctor advised him to take rest. In this regard, doctor issued a medical certificate, lordship. And this is annexer 1.
Which by order?
Order annexer 2.
No, it's a, well, issue notice heard Mr. So-and-so land counsel for the petition. Land counsel, this is an application for restoration of contempt case being WS contempt case within brackets number 19 of 2020, which was dropped on 16/07 to issue notice returned by 4 weeks. This after 4 weeks. Petitioners to take steps for service of notice of response.
Please, your lordship.
Yes.
May be allowed to withdraw this petition, lordship.
Yeah.
No, lordship.
What?
Wait petition, lordship. The matter is settled between the parties.
Okay. Mr. MS so-and-so, P. Saharia.
Peace, your lordship.
Saharia land counsel for the petitioner submits that she has an instruction to withdraw this petition as the parties have settled the matter outside the court. Is the
And for respondent number
Mr. So-and-so land counsel position is present. Accordingly, a writ petition stays closed as not pressed, huh? Closed on withdrawal.
Yes, sir.
In view of order IA, huh? IA also you.
Yes.
49. Item 49.
This is- What is this? There's no.
Item 49.
Non appears for the petition on call list after 4 weeks.
Item 50.
May I please, Lord?
Yes.
My lord, this is regarding cancellation of the mining permit, my lord.
Yes, why this has been listed today?
My lord, for order, they are not filing any affidavit, my lord.
You file affidavit, why?
Yes, Lordship, 3 weeks time may be granted.
No, my lord, already.
My lord, counsel for the petition.
The last, my lord.
2 weeks, we'll give them.
No, my lord, let them, my lord, gives 2 weeks, I don't have any objection, my lord.
Then,
But the issue is, my lord. No, my lord.
you have come running or what?
Yes, my lord.
Have some water.
Thank you.
Give some water to him.
So, my lord, my only prayer is, my lord.
Borrow, give some water. Nowadays,
My lord, I am the agent of the, my lord,
nowadays
PWD.
it's very difficult. You cannot take risk.
No, my
No
lord.
worry, I can spare another 15 minutes of the lunchtime.
Only 5 minutes, my lord. My lord, my prayer is, my lord, I am a contractor of a permit, my lord. Now,
We know, we need
no, my lord, I don't have any objection. Only question is, my lord. Now already my main agents, everything is, my lord, sitting idle, my lord. Huge financial losses, my lord. Now my permit is, my lord, this is regarding payment of forest royalty. Now I am paying the forest royalty as per the LOI, my lord, and the royalty which is specified in my LOI. Now they have suddenly issue. Now according to that LOI, my lord, I am 2 years, I have already, my lord, operating the mine. Now suddenly they have did, my lord.
Yes.
They have issued an order.
Yes.
Saying that I am defaulter of keys money. My lord, keys money is not applicable to me.
Heard Mr. Casing, counsel for the petition.
My only prayer is let them file a affidavit, my lord, within the fixed date, my lord. Or, my lord,
For that, I'll not allow to hear that submission. I cannot spend 15 minutes.
My lord, fix a date only. That's why I'm saying.
So, it could have been finished within a second also. Why say 5 minutes? Heard so and so land counsel for the petitioner. Is spread for by the land council so and so nam pura de. You give all the name. A further 2 weeks time is granted to file affidavit.
My lord, the last chance, because already so many occasions they have taken time, my lord.
It's okay, we'll see. Give the fixed date. We'll give the fixed date after 3 weeks.
My lord, in that case, my lord, my interim may be clear because, my lord, consider, my lord, because my interim was there.
2 weeks, 2 weeks. We'll see. But you file, huh?
Yes. Obliged, Lord.
Obliged,
Versus part 1 list almost finished.
Huh.
Now there's one hearing matter I find.
Huh.
It's my matter, I think 50 Lordship is fixed for the time being.
Where
But
is?
it looks like, my lord, he has not come. So can I submit, my lord? Can I take it next Tuesday or Wednesday, my lord? Because his lordship has got a hearing matter part.
As
maybe a second.
read by the land council, land senior council. No, as read by Mr. Land council, state council. And the prayer not been objected to by land senior council, Mr. Emnath. Let this matter be decided after a week.
Not my lord.
After a week on Friday. We'll dispose of it on Friday.
My lord.
Friday, next Friday.
Can you give a date, my lord? My lord.
5th.
Obliged, my lord.
Whatever this item
Yes.
51,
Yes, I have received the instruction, Lord.
saying what?
Lordship, that requiring department had deposited the money. And petitioner, they were also informed to receive the same, but they are not receiving.
Okay, then we'll take it up at 2.
Yes, my lord.
We'll see.
Yes.
We'll take it up. You take it?
No, my lord. From the affidavit, for the first time we came to know regarding this time, regarding this. No, our case is not this compensation. I will make my submission at 2, my lord.
But I am rising, we're supposed to rise
the
at
315
350.
reference.
Before there are other than part-heard method. This is also part-heard method.
Part-heard method, my lord.
I've heard you.
No, my lord. On merit, my lord, my fact is yet to be heard, my lord. On merit, lordship.
You want your land back?
Yes, absolutely. My land
That's all.
back, land back and area rent.
We'll direct.
Yes. And even, my lord,
Send it.
PW also says they are ready to give us land, my lord. Yes.
Better and
Yes, my lord, that
So what do we say?
We have already handed over the matter to the PWD.
So you have no objection,
No objection.
whether it is given back or
We
not.
already handed over the matter.
We want to get back our land, my lord.
PW also wants to.
Yes, India.
2 o'clock. We'll take it about
At
2
2 o'clock.
Submission and a prayer, my lord, small prayer. I have to leave the court because of my passport renewal appointment at 3 o'clock.
Where are you going?
My lord, my passport office, I have to go to the.
Where you are going?
No, I am not going, but my passport has already expired into December.
Is MS Gyan's identity is crisis?
Yes, my lord. No, my lord.
Your identity is in crisis?
No, not that.
Then?
That has been expired in.
Why you need a passport? Okay.
Opportunity came and then.
Who is appearing in this matter?
My junior will be there.
No, it's okay. You have no objection.
No
You have nothing to do with the land. You have already returned. You have given the payment also.
Also, my lord.
Okay. Who is appearing? Nayak. You have the instruction, but be ready at 2 o'clock.
Yes, my lord.
We'll close the matter. Too.
Yes.
Huh? Misinterpretation or miscommunication or communication gap? Item 48 you are withdrawing.
No, yeah, what?
IA withdrawn. Same order. IA withdrawn. And the MS so P Sahariya learned concept for the petition. I think I have signed it.
Earlier already order is passed because that is now.
Today it's
Yes, today itself. And I'm appearing for NSA.
For IA withdrawn, same order, but whatever, then writ petition. In writ petition, so and so, 3 weeks time is granted to file affidavit in reply. Interim order is there.
Was there.
Interim order to
And
continue.
my name should be recorded. She go to for NSA.
IA withdrawn, same order will remain in IA 48. Writ petition you write 3 weeks to file. Yes, Gogoi. This matter has been, it's a part-heard method.
That regarding my lord, the land requisition.
No. This is termination. Termination. Advocate General, learned Advocate General is supposed to appear.
Then also after some time.
After some time, then.
I did 51.
Well, regarding this particular case, for the first time I'm hearing, to submit that, we don't want the land, it will be difficult. Can it be on Tuesday, I will make the.
But without that instruction, it will be difficult on my part.
No, last time the Nayak said that he doesn't want, he
Then,
want
my lord,
to.
he is coming, my lord, for this series, my lord, 51 to 55. Then, my lord, after some time, this matter will be taken up.
There's no other case.
Oh.
Before the, my lord friend coming, the factual background.
Yeah, let him play the factual background.
So already this is not 1,024 according to the factual background. That orders the character for adjournment of the constitution. 5/2024.
Which one?
5/24 the order of the factual background is recorded by so.
Page 5-1. Yes.
Can I read the paragraph through?
Yes.
From 12. The specific case of the petitioner, that there are parcels of land and become versus government by Lakhimpur Central Court. Citation part 2, Farnsara petitioner district last survey, petition by the Lakhimpur on 1964 by the ground that were destroyed for maintaining supplies and transmission of the life. The community is established on a headquarters DSF Pakaribaram Central Subdivision, extending the power under section 29 after taking possession of the revocation land, the parcel of land were taken upon the respondent authorities in the Union of India. In further testifies that land acquisition proceeding was initiated by the Petition Counsel for acquisition of the same parcel of the land by essence of notification of the section for the Land Acquisition Act. In the schedule of the same notification, petition parcels of land were mentioned for acquisition. It was only on 21/6/13 the declaration under section 3 of the statute was found to have been issued. From that stand taken by the respondent authorities in the Union of India under activity opposition, which is revealed that Deputy Commissioner Counsel estimated the amount of compensation for the acquisition of the entire parcel of land should be acquired in the LNS Central is allowed. It has also been stated by the respondent authority in the Union of India that the said amount of rupees was deposited by the Deputy Commissioner Counsel of Central on 8/2008. The petitioner has stated that they were neither made aware of any award under the land acquisition of nor they had been paid with compensation of any land cost being by LNS demonstration. From the state taken by the respondent PWD Assam in the affidavit opposition, it is revealed that the parcels of land purportedly belong to the petitioners were handed over later on by the Deputy Commissioner Counsel of the PWD Assam for the purpose of construction of the road, the existing RCC. From paragraph 44. In this repetition, the petitioners with the above facts have contended that during the period within which the parcels of land were under requisition from 1960-2004 onwards, the petitioners have received the last requisition rent only on 5/2005, and the memo dispersing requisition rent did not also disclose the period subsequent to 5/2005. The petitioner did not receive any requisition rent till date. From the above conclusion of the fact, it appears prima facie that the parcels of land of the petitioners mentioned above have not been acquired by following any valid process of acquisition as responded till date, have not brought any record on the regards the termination of the land acquisition process initiated in IIT's LAK's number under land acquisition, since the amount would be to have been deposited by the respondent authority in the Union of India, the said amount has not been disbursed for the Deputy Commissioner Counsel till date. It is not possible for this court at this stage to arrive at the final opinion. What would be not the subsequent paragraph to draw the file affidavit? Now, we lost the extent of the PWD page 73 affidavit of PWD. Respondent 5/6. That's 10. Yes. Now, this paragraph is specification of electricity.
Page
73 and there are 3 at page 74.
Seven,
74 paragraph. Affidavit filed by respondent number 5 and 6. This is PW.
Why is this same thing? $74 is your reply.
My report is 73 the examination. They have filed it on 6/5/2020.
Respond number 3 and 4.
No, Miller. Respond number 5 and 6. PWD.
Additional affidavit.
No, the affidavit of which. They have filed on 6/5/2023.
What is this?
Hmm?
Six.
Six is additional affidavit. Affidavit in reply. Affidavit in reply.
reply. Addition.
34. 34.
Yeah, 34.
Why you are 70, saying 74?
Nearly not fine. While they have filed, I found in 73.
No, this 34. Where?
That with regard to state of creating paragraph 9 and 10 of the petition. The deponent makes to state that it is stated that the additional deputy commissioner Kasar Shilchal, respondent number 4, by letter dated 27 to 19, so the view as to a relinquishment of land and handing over the site to the particulars. The undersigned, that is the respondent number 6, by this office letter dated 7/12/2020, that is annexed 12 kilo, informed the following the additional deputy commissioner Kasar Shilchal that a plot of land measuring 5 acres, 9 cutters and 5 shutters over the street of Koregan and Takigara were taken over by this division from the 112 RCC BRTA 15 along with 29 numbers of accumulation over the land. The BRTA, while handing over the land, had not mentioned anything about the partners or payment of any rent to them. So this division is quite in doubt about the landowner and the payment of rent there. As such, it was requested to approach the partners, justify their claim with relevant papers and require agreement with the BRTA so as to take appropriate action. A copy of the same letter was forwarded to the respondent number 2 and Act 25/11/2020, but no document found since yet. This document 25/11/2020 law in my repetition, page 33 paragraph 12. The letter from the respondent number 6 to respondent number 4. Now I'm going to take a lot of kind attention and accept.
Why you are saying respondent number 6 to respondent number 4?
Yes.
What do you mean by that?
Respondent number 4 sought information from the respondent number 6 that he's replied. So I have enclosed both the letters, an extra 10 and an extra 12 in my repetition.
So what do you want to show?
Yes. That is an extra 10 is 31 below. Letter from additional deputy commissioner to the respondent number 6, the executive engineer PWD. Page 31. Regarding the increase of our land. Consequent finding, with reference to the substantive caption above, I am informed you that the land measuring number under possession of the BRTF section. The land was vacated by the BRTF authority and handed over to the PWD and requested to relinquish their land and handed over the said land to the partners. In this connection, you were requested to submit your views regarding relinquishment of the land and handing over the said land to the partner. Then the deputy commissioner requested respondent number 6, then this land was handed over to the PWD by BRTF. Now they requested you what the step they are going to take regarding relinquishment for land. And accordingly, reply of the respondent number 6 and page 33. And it's a 12. With reference to the above, I have the honor to inform you that the land measuring was under the possession of BRT was handed over to the PWD signature authority on 16/12/2015 along with 20 numbers of accommodation. In this regard, it is pertinent to state that nothing was mentioned by the BRTF regarding going of the land in question by some partners. Also, the BRTF in a handing over note mentioned nowhere to relinquish the same land and hand over the partners if any appears in future. The one set of documents of handing over and taking over the same land is enclosed here for favor for time ready reference. Under the above circumstances, the claimant partners may approach. We may approach to justify the claim with all the specific relevant papers, including agreement copies of the BRT, so as to enable to understand to take appropriate action in this regard. This is the letter 7/12/2020. But Milord, the PWD authority has said that if we approach to them with regarding with regarding our positional documents to lot that they are ready this out land. Can we approach before this court, and subsequently all the departments find affidavit, and this honorable court and that the order has read, in paragraph specifically, there is no due procedure taken forward so far as in land acquisition. There is no litigation cases concerned. Now we are before this court, we are not concerned about the compensation. Now, our space, we make only two specific prayer in the petition,
Tell us, what is your prayer?
First prayer, the land possessed by the PWD at present, since 2015, let's say maybe you ask, and second, the rank, 2005 to till date, whatever the rank we entitled, let them be calculated, properly calculated, and whatever rank we entitled, let them be released. We're not seeking that. And even, in the affidavit, in the Respondent 1785, they have said that we are no more ready to father you to lease our land to them. Even PWD authority, my land.
You have leased it.
No, we're not ready. Yes, our father, in 1964, that land they have acquired, no procedure they have followed, though there is land acquisition process initiated, but no conclusion they are finally, So our land, just 2005 came that their NPWD authority enjoy, not the single payment made to us, and either release our land, not making any payment. So before this court, so let them release our land, and whatever land we are entitled for the 2005 onwards, let them release it.
When they have not used the land, that's why you saw us the agreement where it was given for lease.
Union authority, the commanding authority, it is all the document, whatever, why can I record our land? It is with them, and PWD 2015, they are ready. Now, at present, our land with the PWD,
No. When you are claiming for rent, was there any agreement of lease? Is there any lease agreement? It's a recorded prima facie.
The rent copy.
Huh?
Last rent.
What is the agreement?
I think that there is no dispute on the part regarding payment of rent,
It's not a question of payment. Suppose you have received the rent for certain period, and they have not used the land for so many years. How can it be allowed you to? Huh?
And except to the land receipt, and except to page 21. Also, you will find page 22, the last price lot. The right side lot, 5 May 2005, this is the last right.
It's okay. You might have received how? What is the agreement to lease? You are saying that they said that there was a process of acquisition, and it was given it to the BRTF.
Yes.
Then they have relinquished it. PWD 15. And this was of 2006.
2005.
2005, no, 2005 or 6.
5 August.
So,
the 2005, without our knowledge, we are handed over to the land PWD, and since 2015,
so was that the agreement of lease?
Agreement of lease, the government document, the authority.
Where it is?
1788,
Huh?
On what basis they have took our land, all the documents with them, Respondent number 1, 2, 1, union. Let them.
Where it is?
My land friend representing,
Do you have the lease agreement? On lease? $36. 5 and 6.
1788.
Huh? Affidavit of position filed by respondents 51. Said Muhammad Kirmani. Yes. Annexure? Okay. Para?
The title is very fast. I think I might have
Just wait. Paragraph, you tell us the paragraph. Roman 2.
Roman 2.
Roman 2, yes.
On slips from the landowner since 1987 for establishment of 409 RC by Project Woodstock, and consequently building and land was taken over by 97 RC by the Project Woodstock, and consequently building and land was taken over by the 97 Project in effect of Entry 1 April 1997. Land of the state land was paid as per land request for the Deputy Commissioner. Land acquisition funds district government instant a case of for permanent acquisition of the land measuring 5 bigger 9 katha plus
5 bigger 9 katha 0 chataks are your land.
Yes, 2 bigger.
2 bigger.
was taken up the district government by
The power administration is the assessment along with connection district.
So forwarded the estimated this is the estimated cost, and we can send over the estimated cost of it. And after that, there is no lease agreement signed.
After the process of acquisition was initiated, it was not finalized also. You have deposited the amount. Yes. Yes.
And Lordship, I have that given the instruction, it also says that that amount has been deposited, Lordship.
Yes.
Paragraph 3 of my instruction, Lordship.
It is a matter of after 2000, the requiring of department submitted an acquisition proposal for sale. The acquiring of deposited the estimated amount of the okay.
So they did not receive the amount.
So money is still with you.
Yes, yes.
Okay. Suppose if it is this is acquisition under 1894.
Yes, yes, Lord.
If it is to be relinquished, as on the other day, Mr. Nayak has submitted that you want to relinquish it. You return it back to the landowners.
It appears, Lordship, it's an old matter, Lordship. We find our affidavit on the basis of document, we were under our control, Lordship. But now it appears, Lordship, initially this plot of land was requisition, and for that requisition rent was already paid. Subsequently, Lordship, in the year 2008, the concerned land was acquired. And
Although there is no record to show that the award was not.
Award was also passed, and the concerned party has deposited the said amount with the.
Where is the award? There is no award. Only estimate was.
Deputy Commissioner will have to, but one document is at least there that the SBI Silchar check number so and so dated 8 April 2008 for rupees 6,36,665 on account of land compensation in respect of subject land is enclosed here. So the party has already deposited the amount with the Deputy Commissioner. Now, this instruction says they are not collecting the award.
Yes.
So that is the standard as of now. So there is no question of relinquishment of the land, no question of returning the possession of the land. They are only required to go to the office of the Deputy Commissioner and collect the compensation they has been awarded. That is the position.
No, absolutely. My Latin friend without projecting case is different. That amount was released so far as without land acquisition case is concerned for. My case without that process, my Latin friend different.
No, that was the understanding earlier, and I have already stated the affidavit filed by the PWC was on the basis of document in our possession.
Thus, Lordship, I have shown in Lordship 2019 and 2022 documents from the additional Deputy Commissioner as well as from the PWC.
They specifically deputy commissioner requested to relinquish the land, you give your views, so far they relinquish of land. And it similar to the 2009, the amount of 2008, now to the 2019 letter, and additionally, this year they are very much a very lot. Therefore, they have written for relinquishment of land, and then the Finality authority, their own letter.
No, what about the acquisition?
There is no acquisition process below.
There is. Amount has been deposited.
So, our case with our land, have to get, return back our land.
No, you cannot. If it is required for public purpose, you cannot object to it. That you may say, if at all it has to be acquired, it has to be as per the procedure. You may say so.
No, so I will quote that order, specifically recorded, there is no.
Recorded prima facie.
Yes, admittedly,
Prima facie, recording was a prima facie on the basis of the documents. Now things have been changed. See, that's why this matter has been, adjourned for so many. We want to now, we would like to know the real facts. This has been, it appears that wrongly, rightly, the land has been acquired. So if you say that it has not properly acquired, we'll see. It's not that you just cannot stop the authorities from acquiring the land. Law is very clear.
We cannot stop the land. Since we not very simple, and I make my submission lot. Since 2005 onwards, admittedly not before approaching before this not a single payment here. My father as well as my asked repeatedly we made representation to the authorities concerned. Therefore, the additional data 2019 we not when we received our representation. So
see, after 2000, the requiring department submitted an acquisition proposal for after 2000 page. What it is? No, this is the instruction. So you, according to you, land has been acquired. Therefore, if you have to take the this thing, you have to take the.
I think at this stage, Dr. will direct the deputy commissioner to place whatever records they are in possession as regard acquisition of the consult.
Yes.
That is the
Yes, no.
Again, deferred.
Yes, ultimately
That will clear all.
Absolutely.
Heard Mr. So-and-so, learned counsel for the petitioner. And also all of them, huh? Having heard the learned counsel for the parties, come on. No, next one. Huh? In view of the instruction placed by the respondents that the land in question has been acquired under the Land Acquisition Act 1894 after 2005 and the compensation amount of rupees, how much?
6,36,665.
6 lakhs and so and so.
636,665.
Has already been deposited before the deputy commissioner. And having considered that the petitioner having considered the submissions that the submission of petitioner that the land has never been acquired in accordance with the provisions of Land Acquisition Act, I deem it appropriate to direct the deputy commissioner Kachar district to place the entire records with regard to the land acquisition in question on the next date fixed.
Lordship.
You kindly ensure that on next date it is disposed of.
Yes.
You just place the documents.
Lordship.
This stuff accordingly. Next minute.
Lordship, may kindly allow me 3 weeks time because it's a old.
In view of, let this matter be listed after
3 weeks, Lordship.
3 weeks. We'll fix that.
Lordship.
On give the date on so and so. on which the Deputy Commissioner and the Land Council shall place the documents as directed to be produced from the Deputy Commissioner, Kachar district. Huh?
23.
It will remain in Pathar.
Yes, my lord.
Method shall remain Pathar. Huh?
Obliged.
Yes.
Lordship, on behalf of Advocate General, Lordship, I am starting the submission.
No issue. Yesterday, but we have decided not to hear other.
Yes, Lord.
Except the learned Advocate General, because this matter has been adjourned on many occasions on the ground that learned Advocate General is engaged in or busy in some other
So
matters.
Lordship will not hear me?
I'll not hear you. Anyway, it doesn't make it.
I apologize then.
I think it's no. I think it's not recorded. No, it was the oral. I mean, orally, it was expressed. It was expressed orally. It's not recorded. Anyway, you may start.
Lordship, I can convey here.
Yes.
Also.
No, it's okay.
Today, Lordship, time.
Because it's been at least at least not less than 4 or 5 times.
Yes.
This has been adjourned because they,
for that, Lord.
for want of London Advocate General. Anyway,
Lordship,
you complete today.
No, Lordship. Today I'm only taking one case, Lordship, that is filed by the association, Lordship, 3422/2020.
That's all.
No, other
We'll decide in a
Lordship,
we'll
this
decide.
case, this more or less, this case will cover all the cases, Lordship.
That's
But
what I'm saying.
One case is there wherein stay has been granted. I mean, protection has been granted to the petitioner firm. They are enjoying salary in one case.
No, we'll complete. We'll decide the matter in a go. This will be decided. It will be decided
In
by
that
the
case,
common order, common judgment.
Lordship, if
Not take more than 15 minutes.
no, it will take some time. Lordship.
Yes.
If Lordship intends to go in one go, Lordship, then in that situation, Lordship will take up this matter on Monday, Lordship.
No, Monday will be another matter. I mean, are you?
Lordship, today I have prepared only.
What is the guarantee? There will be few cases on Monday.
Today.
Rather, that will be.
No, today.
You start.
Yes, Lord.
Finish it by 30 minutes. Within 30 minutes.
Lordship, today I am just taking up one case only, Lordship.
Yes, one case will be enough. This first case will be enough. Matter is very simple. What they are saying is, you might have. Are you prepared or not?
One case I am prepared, Lordship.
It's one case only. Same thing.
Then SN 20.
This matter.
No, it's a voluminous. It's very voluminous, but then matter is very simple. Anyway, you start.
Lordship, I am in WPC number 3422/2023.
Yes, by the association.
By the association.
Yes.
Herein, Lordship, the petitioners association is stating that they are representing 771 numbers of employees, those who are released from service, Lordship, contractual service.
Yes.
But however, in the writ petition, Lordship, they are able to annex appointment letters only in respect of 65 numbers of persons, Lordship.
Yes.
So far as the remainings are concerned, they are unable to produce any letter of their appointment on contractual basis or on whatever basis, Lordship. That is my first point, Lordship. Then, Lordship, I am coming
Appointments letters of only 600?
Out of 771, they are able to produce appointment letters only of 65 numbers of petitioners.
65?
Yes, release employees.
Yes.
Lordship, first appointment letter is at page 27, Lordship. Page 27.
Yes.
Lordship, if comes to, this is dated 17/8/2013. If Lordship comes to the subject, engagement of mechanic apprentice. First paragraph, as approved by the MD, you are requested to engage the under noted ex-students of ITC Guwahati who have qualified in the test and interview conducted on 7/8/2013 as mechanic apprentice for a period of 1 year. So these are the 11 numbers of persons, Lordship. Contractual, 1 year, 1 year. Next page, Lordship, 28.
Yes.
Mechanic apprentice. As approved by the MD, you are requested to engage the under noted ex-students of ITC Guwahati who have qualified in the test and interview conducted on 7/8/2013 as mechanic apprentice for a period of 1 year.
Yes.
So this is also for 1 year.
22 plus 11.
Yes.
33.
33. Then the next appointment is at page 33. Page 33. Page 33, Annexure 7, subject to termination of contract of engagement without notice or assigning any reason thereof, the following apprentice mechanics undergoing practical training in ASCC are hereby engaged as mechanic on contractual basis with a fixed monthly remuneration of rupees 11,000 only per month for a period of 11 months and posted under different establishment as shown against their name. So in this list, Lordship will get 37 names, Lordship.
37.
Contractual basis, mechanic, 11,000 fixed salary for 11 months.
37 plus 33.
Yes, Lordship.
How much?
Lordship, in total it comes 65, Lordship. Next is that page 38.
48.
38.
38. 1.
Maitri Guhai Pukon, who is undergoing training in accounts. Headquarters is engaged temporarily as office assistant at a lump sum fixed pay of 12,000.
70.
Only per month.
71.
This is 71.
71 persons. Including page 38. 39.
37, 22, 11, 1, 1, 1, 2.
So many.
75. 75 more. 30, 50, 57, 59, 59,000, 69, 70. 75. Total it comes 75, Lordship. Next is at page 39. Therein also Lordship will get one name. 39. Page 40. Again one. And page 42, 2 names. So total 70, 75. So it is the claim of the petitioner association that they are representing all the 771 persons, but they were able to produce only names of 60 appointment letters of 75%, Lordship.
You said 765.
Yes, 771.
75.
75.
According to you.
Yes.
What is the factual position? Are these 771 were engaged or not?
One table has been given, Lordship. I am coming to that point, Lordship. If Lordship comes to my affidavit, Lordship. Affidavit start from page 88. It is an affidavit filed by the ASTC, Lordship. Lordship, I am at page 97, paragraph 17. Page 97, paragraph 17.
Yes.
That as regards to the statements made in paragraph 16 of the petition, the deponent begs to state that in the review meeting of the Transport Department held on 27/6/2022, chaired by the Honorable Chief Minister Assam, considered the issue of engagement of large number of contractual employees and the allegation that entire 2274 numbers of persons were recruited without following the due procedure of or following the system of reservation, nor any interviews were held. Accordingly, a decision was taken to conduct an inquiry verification process into the matter, and that if the allegations found to be true, to issue so cause notice to the then Managing Director ASTC for flouting the government norms, and also to initiate departmental proceeding against such government officers. It was also decided that after inquiry and on assessment, the Transport Department would go through the then existing contractual staff of the ASTC, and appropriate direction would be issued to keep only the essential and largely legally appointed staff, and other staff to be released immediately thereafter. The said exercise was to be completed within a period of 60 days. In view of the decision taken in the review meeting dated 27/6/2022, a report was prepared in respect of 2,274 numbers of contractual employees and placed before the Secretary Transport Department on 5/8/2022. On the basis of the report dated 5/8/2022, the Transport Department, Government of Assam, filed letter number so and so dated 11/8/2022, directed the Managing Director ASTC to submit full details, including the copies of appointment letters, if any, dates of contract extension, along with copies of contract agreements. The report was submitted by the Managing Director ASTC by letter number so and so dated 16/8/2022. And on verification, findings have been as endorsed on 5/9/2022 in the note sheet of the departmental fine number TMB 104, stating that there are 2168 numbers of contractual employees under ASTC working in various categories, and over a period of time during the tenure of Managing Director ASTC, Sri K.N. Setia, 235 numbers, the Managing Director ASTC, Sri A.P. Tiwari, 536 numbers, a total of 771 numbers of contractor staff were engaged without following the procedure of advertisement and written test or interview. Moreover, a large number of contractual employees had not signed any agreement, and agreements which had been signed were valid till 31/1/2022, and as on 5/9/2022, no contractual employee of ASTC has valid agreement. Thus, out of 2168 numbers of employees, 771 were discontinued, and the remaining 1397 employees are retained. On the basis of such exercise, the review meeting of the Transport Department held on 29/4/2023, chaired by the Honorable Chief Minister Assam, took the decision inter alia not to renew the contract of 771 numbers of contractual employees who were recruited by not following the procedure of advertisement and other requirements of public employments, and to release them. On the basis of such decision taken by the review meeting dated 29/4/2023, the Board of Directors ASTC, in its meeting dated 24/5/2023, gave its approval to the decision not to renew the contract of these 771 numbers of employees after its expiry on 31/3/2023 and released them. As a consequence, by order number 1 to order number 771, all dated 25/2023, these 771 numbers of contractual employees of ASTC have been released from their contractual engagement. So basically, this is the decision, Lordship. Then Lordship, it comes to paragraph 18.
So what about these other writ petitions? Just wait. What about other writ petitions? These writ petitions are also within that 771.
All 770.
The same thing, huh?
770.
Yes.
page 18, Lordship.
Para 18.
Sorry, para 18. That as regards to the statements made in paragraph number 17 and 18 of the writ petition, the deponent begs to refer and rely upon the statements made in paragraph 16 of the affidavit and further begs to state that conscious decision was taken not to renew the contract of 771 numbers of employees beyond 31/3/2023, on which date the contract period of these employees expired. Further, in view of the well-settled principle of law that the appointments made on contractual basis for a specific period of time comes to an end by a flux of time, and the person holding such post can have no right to continue on the post. Even if a notice would have been served upon these employees, same would not have make any sense on the fact that the period of their contractual service expired on 31/3/2023. Then 19, Lordship.
Yes, it will explain.
Yes, not to replace that outsourcing. Lordship. 19 statement is there. Annexure 13 of the is a non-existing document, as has already been mentioned. It is further stated that it is not a correct statement of fact that the respondents are going to replace one set of ad hoc employees by another set. So these documents are, Lordship, I am placing, Lordship, if Lordship comes to the first document, annex at page 104, that is annexure 1.
104.
This is the review meeting dated 27th of June 2022.
So according to these 771, they were not properly recruited. They were even appointed on a contractual basis.
Yeah.
No selection process was followed. There's no selection process.
In respect of this 771.
But when these appointment orders are shown that by virtue of maybe 1 year, in view of the interview conducted, it clearly shows.
That specific document, Lordship will get at page. If Lordship comes to page 43 of the writ petition. Lordship, this is the decision, Lordship. From page 44, Lordship, one table has been given. Lordship will get the status. Page 44. Lordship, this contains the details of the contractual employees under ASTC, where due procedure of appointment.
Okay, it's your decision. Now, what about these appointment orders?
Lordship.
What about these appointment orders? Your decision I've seen, but then I'm not saying that you cannot take a decision, but then these appointments, you just read page 27.
Lordship.
One of the appointment. You are requested to engage the undernote ex-students who have qualified the test and interview conducted on certain. What does it test and interview?
I'm not saying that all the appointments, but the advertisement. In this case, Lordship, interview was there, but advertisement was not there.
Who has done that?
By the authority, Lordship.
So,
action was taken against it. We have also taken a decision to take action. All the MDs, Lordship.
Have you taken action?
Yes.
You have taken an action?
Yes, it has already
against the MD?
Yes.
Who has appointed this person?
3 MDs, Lordship. We have even given the numbers who have engaged how many. Lordship. So one KNCT.
No, whether there have been any action against them?
Yes, one has already retired and one is still continuing, Lordship. He's an IPS officer.
No, whether you have engaged them or not. I mean, initiated an action against
them. Decision was there, already there.
No, decision, forget about this. After the decision.
If Lordship comes to this affidavit, Lordship, decision was already there to take action against all.
That's why I'm asking.
Actually,
any action has been initiated.
Yes, it was initiated, but that what is the status, Lordship, that I have to take instruction?
No, as per this, you said that the decision has been taken to take action.
Yes.
But we would like to know whether any action is taken or not.
Lordship, I will place that instruction.
Anyway, that is something different.
If Lordship comes to page 44, Lordship.
Page 44.
Lordship, from page 44, these are the details of the contractual employees under ASTC.
Yes.
Where procedure of appointment was not followed.
No, that's what I'm saying. When you have said that there was test and interview,
The interview is not the complete procedure, Lordship. In some cases, interviews were there. In other cases, Lordship had sealed the appointment letters, no interview was there.
Whether the selection procedure.
If Lordship comes
What
to
is the requirement of, what is the selection process? Consist of what?
If we go by the rules, Lordship, then one advertisement is the absolute necessary. That is the law. Then Lordship giving appropriate opportunities to all the eligible candidates to appear.
How these, the persons whom you have retained, 1,000 something,
Yes.
how they are appointed?
Lordship, their appointments were found legal, Lordship. That is why I'm.
How it is legal? At least they could show that their appointment, as per their appointment order, they were test and interview.
Yes.
How this rest of the employees which you have retained, something 1,000 something?
Lordship, one inquiry was conducted. After the inquiry after that inquiry, Lordship, this table was prepared at page 44.
Let us see the inquiry. Is there any inquiry report?
Inquiry report is in the record, Lordship. It is not enclosed, but record I have, Lordship.
You have the record?
Yes.
Saying the how, that's why I just wanted to know, since you have the record, how these persons who have been detained, how they were appointed?
Yes.
They were also under contractual basis?
Yes.
They were also appointed on contractual basis?
2136 or
2136 something like
that is the total number of contractual
which who have been retained.
Some out of barring this 771 remaining.
That's why I would like to know how they were appointed, since you have retained them and since you have said that these people are been appointed by following the procedure.
Yes, sir. But if Lordship comes to page 44, Lordship. This is the table, Lordship, about this 771.
Yes, I can understand.
Yes. If Lordship comes to last two columns, Lordship, Lordship may kindly see the headings, whether due selection procedure followed, open advertisement and interview.
Yes, yes.
And the last one is whether contract agreement valid as on date. Lordship may kindly see the fifth column, Lordship. No procedure was followed and their agreement was also not valid on the date when this inquiry was conducted. So this continues up to page 46, Lordship.
This is a different post.
These are different posts.
This 771 is in a different post.
Different post.
Not only mechanic.
No, mechanics are there, mechanic helper there, Lordship office assistants are there, security assistants are there, computer assistants, grade 4 driver, supervisor, assistant supervisor, manager, internal auditor, assistant engineer, foreman, all the posts are there, Lordship.
So this 771
it was found,
persons is consists of all these 21 posts. Not only the mechanic.
Yes, Lord.
Not only the mechanic.
Not only mechanic, not only security assistant, Lord.
It's a consist of 21 posts.
21 posts.
Okay.
And total number is 771. So in the cases of this 771, it was found that no procedure was followed. And second, Lordship, no subsisting contract was there on the date when the inquiry was conducted.
Okay. There was no agreement also.
Agreement was also not.
Except for these appointment orders.
Except those, Lordship, who were.
Except the appointment orders, which shows that there was a test and interview. Therefore, they have been appointed for 1 year. Except that there's no other documents.
No other documents were there.
No advertisement, nothing.
So far as appointment engagements are also concerned, Lordship, only these 75s were available. Department ASCC was directed to produce the appointment letters and the approval of the board, Lordship. And on the basis of the record submitted by the ASCC, this table was prepared. Now, if Lordship comes to page 104, Lordship.
Yes.
Lordship, this is the minutes of the meeting dated 27th of June, 2022. This is the first review meeting, Lordship. Lordship may kindly see the first paragraph at the outset, Honorable Chief Minister so-and-so, so he was present. This is a review meeting in respect of the Transport Department. If Lordship comes to page 105, next page, Lordship, the relevant portion. Other issues were also there. Issue relevant to ASTC in the page number 105. Lordship may kindly see serial number 12 is there. 10, 11, 12. Then Lordship thereafter. Thereafter, Honorable Chief Minister directed MD ASTC to give an overall presentation on ASTC matters, and after threadbare discussion, the following decisions were taken. In respect of engagement of contractual staff, it has been alleged that the entire 2274 staff were recruited without following the due procedure or following the system of reservation, nor any interviews were held. The same is to be inquired into, and if found to be true, so-cause notice to be issued to the then MD ASTC for flouting the government norms and initiate departmental proceeding against such government officers. Accordingly, after inquiry and on assessment, Transport Department will go through the present contractual staff of ASTC, and appropriate direction will be issued to keep only essential and legally appointed contractual staff and other staffs to be released immediately thereafter. This exercise is to be completed within 60 days. So this was the decision in respect of contractual employees of ASTC. Then if Lordship comes to page 108. So this is the photocopy, Lordship. This is part of the record, Lordship. It is a note given to the Secretary, Lordship. In the review meeting of the Transport Department held on 27th day June 2022, Honorable CM has directed to inquire the recruitment of contractual staff of ASTC and appropriate direction to be issued to keep only essential and legally appointed contractual staff and other staff to be released immediately. A report in respect of 2274 number of contractual staff of ASTC was called for, and on going through the details of the findings are as follows. So this is the table prepared in respect of 2274 numbers of employees of ASTC. If Lordship comes to the remark column, last column, posts are different, Lordship. Third column, posts are different. Remark column, Lordship. Lordship, in this table, Lordship will also get the numbers engaged by the individual MDs, Lordship. Second column, Lordship, is the name of the MD of that point of time. And he appointed, Lordship, at total number, Lordship. One total is, it's the fifth column, 13. Last column, Lordship, remark, is the first row, Lordship, recruited through advertisement and interview thereof. So far as up to 2000, up to serial number 15, advertisement was issued.
Yes, page 110.
108, Lord. It starts from 108.
No, 110 is what? Only 442?
No, that is the number, Lordship. It subsequently, Lordship, enhanced, Lordship. This number says subsequently.
Where?
If Lordship comes to page 111.
This is, as per this, there is total 442. Then what about the rest?
Yes, I'm coming on. Restored contractual options, that's 2,271. If Lordship comes to page 178.
Yes.
No, Lordship, after those 400, NA again was asked to submit the documents at page 1110, 1111, Lordship. Page 1111. Letter to the managing directors, ASTC. In inviting a reference to your above letter, I am directed to inform you that a report received from your end it should be enclosed with the following documents. So all these documents were asked for by the government lordship. Then I'm coming to page 178.
Yes.
In continuation of the note on 7N to 9N, the details of the total contractual employees under the payroll of ASTC were set. There are total 2168 contractual employees under ASTC working in various categories.
So it's not 2024.
Now it's came down to 2168.
Two one
68.
Yes.
On verification of each category of contractual employees, it is observed that over a period of time during the tenure of MD ASTC Sri K.N. Setia and MD ASTC Sri AP Tiwari, total 771 contractual staff were engaged without following procedure of advertisement and written or interview thereof. Details placed at flag B.
No, total 771.
Yes. Flag B.
Yes.
Flag B. Flag B name 771 and 9. Flag B. Though approval of board of directors were obtained subsequently, few of the employees had signed contractual agreement document, but a large number had not signed any
It's
agreement.
okay. Now 771. Then.
Yeah. Now, Lordship, may kindly see the numbers, Lordship. Next paragraph. Total contractual staff who were engaged without following the procedure of advertisement and written or interview thereof during the tenure of MD STC Sri K.N. Setia is 235 number. Details at flag C.
No, finally 771.
It is 771.
In the bottom, yes.
Next, last two paragraph, Lordship. In the review meeting of Transport Department held on 27th day of June 2022, Honorable CM had directed to inquire into the recruitment.
It's okay, sir. It's now total 77. Huh?
Yes.
Yes.
If Lordship comes to the last line, Lordship.
Yes, I have seen it. That's why I'm next.
Handwritten, Lordship. Honorable CM may take a decision regarding discontinuation of 771.
Again, there was a meeting.
Yes.
Page 179.
179 is the next meeting, Lordship.
Yes. So.
Now, these states, Lordship.
On the basis of this, they have been terminated.
They have been decided to terminate, Lordship.
Okay.
Then it was placed in the board, Lordship.
It's okay. Ultimately, that is procedure was followed for termination.
If Lordship comes to page 84, 184, Lordship.
It's okay.
Two things, Lordship, I would like to show, Lordship. Page 185, miscellaneous items. This contains discontinuation of discussion on observations made in the review meeting dated so and so. Lordship may kindly see what has been approved. 186.
Yes.
So matter placed regarding discontinuation of these 771 numbers. First decision was, Lordship, if comes to the previous page, a decision was taken not to extend the contract beyond May 2023. That is the first approval sought for. Second approval was sought for the purpose of releasing them beyond, not to retain them beyond to May 2023. And if Lordship comes to page 186, one bold line is there. It's after the third paragraph, Lordship. The board took note of the above, principle approved the same. So this not extension and release order has been approved by the board. Now, if Lordship comes to the next paragraph, Lordship. Next paragraph, B, small b. Proposal for engagement of security assistant, etc. Through manpower agency on short-term basis subject to release of 771 contractual employees. MDSTC stated that in view of the observations issued by the Government of Assam Transport Department ASTC and decided to release 771 numbers of contractual employees from their respective services on release of 771 numbers of contractual employees, of which large numbers of employees were engaged to provide security, in the interest of the protection of the assets of ASTC, security assistant may be immediately engaged through security agency, manpower agency, as resolved in 184 BOD, Board of Directors, to ensure that there is no loss or damage to ASTC property across Assam. The board took note of the above and in principle approved the same. So a decision was taken only in respect of security aspects, Lordship. Services of manpower agency will be outsourced for the security purpose, not for any other post.
Large number of employees were engaged to provide security in the interest of protection of assets and security assistance may be immediately engaged through security agency manpower. Okay.
Not any other post, only security assistance, not to be engaged by the ASTC, but to be outsourced from some manpower agency. So that is the decision.
Okay.
So it is not a question of replacing one set of ad hoc by another set. Lordship, this is only outsourced through a manpower agency.
Yes.
So basically, these are the facts, Lordship.
Yes.
If Lordship permits, Lordship, next day I would like to place some judgments. Judgments are necessary, Lordship.
You make your legal submission.
These are only.
You don't have to go. I'll.
No, he will give his reply, Lordship. Other senior counsels are also there. They would also like to give reply. Lordship, I would like to give some citations. Citations are absolutely necessary, Lordship. Citations are absolutely necessary.
You make your legal submission. We have 10 minutes.
So that is basically, that is the case, Lordship. Factually, Lordship.
Then I've understood. Factually, I've understood. What is your legal submission?
My first submission would be, Lordship, a conscious decision was there not to extend the contract of this 771 numbers of contractual employees. And it was approved by the Board of Directors also. And on the basis of that decision, Lordship, that their services will not be extended, a decision was taken to release them. They used the word terminations continuously, Lordship. It was not actually termination. It was released from contractual service on being a decision taken by the Board of Directors not to extend their service beyond May 2023.
Yes.
So the first legal submission comes, Lordship. They have no right to continue in their contractual service, Lordship, after the efflux of time, that is after the expiry of the contract period.
Yes.
So that is one. Second submission would be, Lordship, they being contractual employee. All along, it is admitted fact that they are contractual employees under the ASTC.
Yes.
These contractual employees, Lordship, terms of their service conditions, Lordship, are solely regulated by the terms of the agreement. In some cases, agreements were there. In some cases, no agreements were there at all. So my submission will be, Lordship.
Yes.
Their service conditions being regulated by the terms of the contract, they are not amenable to jurisdiction, Lordship. On this point, Lordship, I would like to place 3 judgments, Lordship. On next date, Lordship, I will place 3 judgments. I will place, Lordship, of Supreme Court, Lordship.
Only one judgment will be enough. Why 3 then?
Lordship.
Then.
So these are the basic 2 points, Lordship.
That main submission you are not, main legal submission you are not making.
Lordship.
Since their appointment is illegal.
On that point also, Lordship, I am placing certain judgments, Lordship, that their appointments being illegal.
This is the main, that is there. That should be your trust and
yes. On that point also, Lordship, I have certain judgment. Their appointments are illegal. It was in violation of Article 14 and 16 of the Constitution, Lordship. And they themselves being recruited in violations of Article 16 and 14 and 16, Lordship, they cannot avail the remedy of law, Lordship. That is my submission, Lordship. Judgments are available on that point also, Lordship.
That's all.
Lordship, 2, 3 other points are there, Lordship. Lordship,
make your submission way.
Lordship, instead of opening my all defenses, Lordship, I will place on the next date, Lordship. At the same time, you will reply, Lordship. Other counsels are also there. On next date, Lordship. Today, otherwise also it can, Lordship.
Sorry, we thought we'll complete this matter today.
Yes.
Of course. Anyway, on Monday we'll complete.
On Tuesday, Lord. Tuesday is a hearing day, Lord.
Tuesday.
Tuesday hearing day, Lord.
Heard Mr. You record all the lawyers, huh? Name of the lawyers. And Mr. P. Nayak, learned additional advocates from the respondent. Hearing remains inconclusive due to paucity of time, huh? As agreed to by the learned counsel to the parties, let this matter be listed again on 2nd 02/09/20. On that day will complete.
Lordship will come.
You have to give the judgment.
Only the judgments and 2-3 other legal points, Lord.
10 minutes.
Lord. 10 minutes.
For you 10 minutes for every, all the council 2 minutes each. I think it's better unless issues are same. You have a conference, engage one of the senior lawyer, maybe Mr. Kaur and anybody, whoever, you decide and make this in 5 minutes will finish. Now you make a mention, we'll finish it up.
It's a part of matter.
If not all this thing, you can come up with the bullet points, 1 page. You also, whatever you have submitted, 1 page bullet points you may give on that day. No further adjournment. On 2nd, we'll finish. Judgment, I don't know what time will be delivered, how long it will take, but then hearing will complete on 2nd. All right?
Lord.
Okay.
Yeah,